there and let Ogden go on, or Senator Driscoll go on, and smiled. And I go, sooner or later he's going to tell him he ran Cargill Meats.
That's good.
So he knows all about a guy with his cowboy hat on backwards and packing plants in Wyoming.
So there was a method behind my madness, Senator.
I gathered that. There usually is. There usually is.
So Senator Driscoll, how are things going in the other committee meeting? Everything all right?
Yeah, I managed to gather my customary 2 votes for my bill in TRW this morning. So,
hey, that's good.
I'm a very powerful chairman.
Ruling with an iron fist. Was Yin your other vote? Afraid not, huh? Okay.
Not only that, he had him talked against me. That's all right. We're all good.
That's great.
You guys take longer lunch breaks now, huh?
Well, I thought it was just an hour. We didn't conclude until 12:30. So
I was on. I jumped off my meeting immediately.
And came over. Okay.
As soon as I lost, I put my tail between my legs.
Ran away good. Like any good chairman. All right. We're getting there. We need Chairman Olson to land, and I think we're ready to go.
Committee.
Mr. Chairman, welcome back.
Strategically and purposefully arrived 3 minutes late, hoping that I would get to see more Avatar building. Disappointed.
Yeah, I see what my avatar's up to without me. I'm not sure.
As soon as you get the cowboy hats, we'll do the avatars.
Yeah.
No avatars.
Mr. Chairman, we are streaming, and I think we've got a quorum, so we're ready to roll whenever you are.
Thank you. Appreciate that. So we'll move right into data trust. This is a discussion point. And give me 1 second to get oriented, committee. I'm sorry. So I know we have Lee. Representative Yin. Oh, hey, Representative Yin.
How are you?
Please proceed.
So this discussion will probably be fairly short because I unfortunately did not get enough done in between this meeting and our last meeting. So if you recall, our last meeting, I talked about how data trust could be useful in the corporate world, where we essentially kind of create a wall around the data. So you have a trust of the data that has fiduciary obligations to not misuse that data. And that was one form of data trust. I think there are some interesting use cases in the materials that I sent to the committee early this morning that hopefully we can peruse over maybe for come the next meeting, where we could have a longer discussion about more individualized data trusts on how they could, you could, for example, trust them with your healthcare data, and then they would have a fiduciary obligation to not misuse your healthcare data, rather than them being a larger trust for a corporation and the corporation's data of your of the amalgamation of all of its users' data. I think ultimately, when it comes to the data trust conversation, it still is a topic of whether we want to classify data as property and what the best way of doing that is. But I'm open to any other opinions. Otherwise, I think ultimately we'll probably have to move more of the discussion until the next meeting.
All right, Senator Rothfuss, please.
Thank you, Mr. Chairman. Mr. Chairman and Representative Yin, with regard to use cases and the, the literature that you sent around, I think provides some concepts and discusses the fact that there are use cases that I think we've seen in other countries. What is the potential for adoption in Wyoming if we get something like this up and running? That's kind of one concept, and maybe that's one for Joel as well that he can weigh in on and share his thoughts on data trusts. And the second question I have is, how does this end up fitting in with some of the other work we're doing? Is there anything that a chartered data trust or something along those lines would do to go along with the rest of the work we're doing?
Mr. Chairman. Thank you, Mr. Chairman. I think ultimately, if we had some sort of data trust legislation in Wyoming that could incentivize from a standpoint of corporations wanting to advertise that they protect your data privacy in some sort as a business advantage for when they advertise to consumers. For example, if you want a social media company that has better protection over your data than the current ones out there, it would be more beneficial to set up shop in Wyoming that has legislation where you could surround all of your users' data in a data trust and therefore guarantee to all of your users that their data is protected. So I think that it creates an incentive for businesses to set up shop in Wyoming, and ultimately better for users, not just in Wyoming, but across the United States if that occurred.
Thank you, Representative. And I'm curious to hear Joel's thoughts on it as well, Mr. Chairman.
Thank you. Joel, thoughts?
Thank you, Mr. Chairman. Chairman Rothfuss, I don't have a strong view or honestly a great use case for this as far as the commercial application. I think there is a way. It is promoting the beneficial use of data, for us as a society, I think there could be some benefits to Wyoming having this as an option, but to date, either I don't know enough, or I don't quite appreciate what the potential commercial use cases could be.
Representative Greer.
Yeah, thank you, Mr. Chairman. So I'm curious, Representative Yin, so in a corporate setting, there's borrowing authority, there's authority for signature of certain documents, certain types of transactions, everything on all the checking accounts. Is this something where you can set that up so that like a bank or a third party, I know I'm going to say a governmental entity, we deal with the federal government, they'll never trust anything, but where you can do that, where you've only got one point, so I don't always have to show board resolutions. I don't have to go change all of the signature cards on all the bank accounts. Is that the type of thing that you're looking at, or is this more what, I don't know. Let me just ask that question.
Mr. Chairman. Thank you, Mr. Chairman. Representative Greer, yeah, I mean, I think in one way it could be used to hold identifying information and therefore be a way that they hold that identifying information, but I don't think that it's necessarily that would be the first thing that we would move on with regards to a data trust, especially regards to the discussion on digital identity. I think that there is interplay between the two, but I think it's kind of baby steps to get there, first of all. So I don't think that would be a first use case of that kind of idea. More so of in the use case that I presented at the last meeting, where all the analytics, for example, to decide what kind of decisions that they make based on your user data happens separate from the company that is creating the implementation. So for example, if we talk about a social media website, they want to make decisions based on your data, for example, for what ads to serve you, but right now they don't have any separated wall between your personal data and the aggregation of that data that they use to analyze, oh, these people like tennis, so let's show them tennis ads, for example. So the data trust legislation in, I believe it was Ireland, basically creates that wall. So if I want to determine something in aggregate from my user data, I can do that through the data trust while I'm still not necessarily knowing the individual items of my user data, if that makes sense.
Yeah, okay. So, Mr. Chairman, okay, I think I understand. I was looking at more of the sort of the nuts and bolts functioning of a corporation. You're looking at it as data from the customers or the clients, and then how that is stored and then utilized by the company to build upon its product. Okay, understand. Thank you.
Co-Chairman Rothfuss.
Thank you, Mr. Chairman. You know, one other use case that I think we touched on previously, and Representative Lindholm was addressing yesterday, is the KYC AML portability. And when you start thinking about how that would play out, what you would ideally want is some type of a third-party entity that could be trusted, where you could have confidence in their data and the integrity of their entity, where if they told you that, yes, we are holding this KYC AML data on behalf of individual Chairman Olson, he is a human and he passes KYC AML, that you would have confidence in that. And Representative Yin mentioned the idea of, what's a great first use case. And to me, it seems like there's a lot of potential to try and explore as we're moving forward, figuring out how to put in place a KYC AML platform with portability that could be trusted by different banks and not just be each bank rolling their own solution. That might be a great use case for us to explore. And it links into, obviously, the identity discussion that we've worked on also. But I think that's one where you want a high level of credibility and rigor in terms of the data surety that any entity that's holding that information would have. And if we had a framework in the state where somebody that was establishing themselves and having a sign up that says we're a regulated chartered data trust or something along those lines, whatever you want to call it, that there would be independent scrutiny from the state. They would be audited perhaps in a similar way, although not identical to how we would audit financial institutions in terms of their integrity. And it seems like this is an instance where the availability of regulation, if you opt into it, could be beneficial as a business model. I think we talked a few years ago, we wouldn't want to be exclusive of this. Trusts right now can be data custodians, and we wouldn't want to stop that, I don't think. But I think if we're trying to create an entity where there's a high degree of public confidence in its capability of holding data assets, whether that's information or really that could also be digital assets. I mean, there's a lot that could be held by a data trust. Maybe it's an amalgamation of the two. I think there's a lot of potential there that we probably need to explore, but I don't know what the appropriate construct is if we wanted to enable that. And I guess a question I'd ask Representative Yin and maybe others in the committee that have dealt with this, maybe Joel, is if you start thinking of really a traditional trust, and Representative Greer has tremendous experience here also, and you think of the asset as data instead of dollars, how do we do that? Because I think that's the objective here. And I'll start with, I'd like to hear from Representative Yin, but then I'd like to hear from others that have experience in this realm if we create that analogy.
Yeah, Representative Yin, please.
Thank you, Mr. Chairman. Yeah, data as an asset. I mean, that's really essentially one way that we can protect users' data, by considering our already structured property rights and structuring them around our data. And I think data privacy is going to be a big aspect moving forward in this technological world that we live in. And so I think the sooner that we try to wrangle how we protect our users and our constituents in regards to this digital world, the better off we'll all be. So I think this is one way that we can do it. And it makes sense given the structures that already exist in place that we can reuse existing structures. So I do hope we'll continue this discussion for sure.
Thanks, Mr. Chairman. I don't know if anyone else has any thoughts. I mean, if Joel, for example, or Representative Greer, if you use that analogy, what's missing?
Joel, you've heard some more here. What do you think?
I think part of the reason I don't quite understand why a trust is the right mechanism for data protection versus some of the other options that we've talked about is that, to me, kind of the basis for a trust is that you're separating kind of title to the asset and giving that to a trustee. And if we're talking about a trust with financial assets, that has certain benefits that come with it around estate planning, taxation, et cetera. So I struggle a little bit to see how that basic construct is optimal for data. But again, maybe it's because I haven't seen the use case, or it hasn't been explained to me in the right way. The other thing I wonder about, and this is just in kind of a cursory understanding of data trust, is that it would not necessarily be a for-profit entity, that it is, like I said in my first comment, sort of something that is for the better good of society, or to protect our data from mistreatment by for-profit organizations. And so I'm sort of struggling to see how at least my sort of understanding of a trust or trust company fits so well with data. Thank you.
And maybe I'd tag on here just a little bit too. I guess I'm curious if there's anything in existing trust law that would prohibit you from titling data into a trust, or using a trust, a statutory trust, in such a fashion. I mean, I don't know that there's a limitation on what a trust can own or not own. It's a process of, I'm not sure how you declare that a trust owns your data or stores it. Representative Greer.
Yeah, so thank you, Mr. Chairman. Yeah, so we're using the term trust. And Joel said it correctly. I mean, one of the things you do with a trust is you sever your direct ownership, one way or the other. You take it out of Mike Greer's name into a trust, And obviously there's different types of trust, but, and why do you do that? You do it for various reasons, as Joel said. But one of those is to allow the continuation past your particular lifetime. Okay, so that's that concept of trust. But I hearken back to like the late 90s, where the big issue in dealing with trust that was the largest struggle was to get third parties, title companies, banks, clerks' offices, just go around that list, those people that regulate what we own in this world, or are the gatekeepers of that, to have trust. I'll use the term trust, but to feel comfortable with who actually had the power and the authority to make those decisions. And so keeping kind of those concepts in mind in trying to filter in what Representative Yin said, that's where I think you got to find those building blocks. Okay, so you're seeing where data can go in and people can feel comfortable that it's protected, but then in the company that may be using that data for their own purposes, if I understood that right, or to develop their project further. So then the next step is, if you're going to use this trust concept, is then how do you portray that? How do you communicate that out to the other parties that you're doing business with, that you have the authority, the actual authority to utilize that data? And so I'm kind of rambling just a little bit, but I'm trying to string this together just a bit. So those are my thoughts, Mr. Chairman.
Mr. Chairman.
Yeah, Senator.
Thank you, Mr. Chairman. You know, this is a great discussion and all good thoughts. And I kind of wanted to address a few, at least the concepts I have with Representative Greer's last point first. I think that's the beauty of the current era of technology, where I imagine if I were to sever my ownership to a trust entity in this era, I would come up with a private key structure or a key co-signatory structure, which allows you cryptographically the ability to engage whatever those digital assets are. So I think it works really well from that standpoint. That's an interesting way to look at it. And I think the technology is there for that building block to strongly be enabled, which is an interesting concept. A couple of other things, addressing Mr. Reville's, a couple of his points. One was with regard to the for-profit. It's my understanding, and we could do it however we wanted, but my understanding is that it would be potentially a traditional trust that is intending to make money, and for-profit or not, but I don't see where there would necessarily be any delineation there. And as far as what you could or would put into it, and getting back to to Representative Greer's question also about purpose, and it transcending your lifetime, as we start thinking about digital assets and digital asset custodianship, cryptocurrencies, but also intellectual property, trade secrets, even my family photos. I don't know, any private proprietary information that I do want custodied, and I want it to survive my lifetime. You start getting to the point where there is potential value there if you can have confidence in the institution to be an appropriate fiduciary of those resources in a trust-like behavior. So I think it does align exactly with what Mr. Reville and Representative Greer are talking about. Getting to your point, Mr. Chairman, of can you do this now? I'm certain you can do it now as a trust. And I had that conversation a few years ago extensively with Mr. Land from Division of Banking as we were sort of walking through, well, would anything preclude a trust from doing this now? And the answer is no. And I think that's true in any state, that they would be able to custody these types of things and act in the same capacity they would. I think the discussion point here, though, is, are they any good at it? And what confidence, getting back to Representative Greer's question, where you want trust in the trust, I think we've established trust in financial trusts because they've become good at it. And I think the unique advantage we could add if we wanted a Wyoming secret sauce would be to come up with some sort of entity, which is a chartered data trust or something along those lines, where we are regulating to best practices, where they are being examined for their capacity to make good decisions with data, above and beyond what a traditional trust might do. And it's almost like the stamp of approval. Yeah, they do a great job with data, as opposed to storing it in the drawer, which, is certainly going to be the case in many instances where I've just got it in my filing cabinet as the repository for my data. If I want a higher level than that, and I want it fully encrypted, I want it in cold storage, I don't know, it depends on the circumstances of the particular data, then how do we get to the point where somebody can say, yeah, I want that next level of protection, and I do want it severed from my ownership. I wouldn't want everything severed from my ownership, certainly. So that's the way I envision it as far as responses. But I will ask the question of Representative Greer also, as far as the severing of ownership. And I don't know if I fully understand. Is it a complete severance of ownership, or do I jointly own it in terms of statute? How does that work down in the weeds in terms of, am I a joint owner, or am I no longer an owner if I have engaged the trust for those assets?
Representative Greer.
Thank you. Thank you, Mr. Chairman. I think I'm not going to speak in 100% certainty here, but the answer to your question is yes, you relinquish ownership over to the trust. Then the trustee has the control, the fiduciary obligations, and sometimes those obligations are to give the assets back to you when you ask for them. So I would have to answer that as yes, you sever your ownership.
Okay, Mr. Chairman.
Yeah, I would tag onto that just a little bit. I think it all comes down to titling is what it is. It's how you transfer the asset, because this is probably beyond what you were actually asking, but you could title an asset so that it is jointly held between you and a trustee. It'd be bizarre, but I suppose you could do it. The other thing that I do know is that whatever the law does say that whatever character of titleship an asset had, when it is transferred into a trust, it maintains that character. So the example would be you as an individual, no, but you and I, Senator Rothfuss, if we do own something as joint tenants with a right of survivorship or common, it doesn't matter. We just own it as a joint tenant. It maintains its character for all other purposes of law, even though it's owned by a trustee or the trust. Probably less relevant so between you and I than with me and my wife. If my wife and I own property as tenants by the entirety, the law says it doesn't lose its character as a tenancy by entirety, even though it is now in the trustee's name. But so there's a. I think that's why Representative Greer maybe didn't want to answer it wholly directly, because it's a little more complicated. I guess it depends on what type of law is going to later apply, bankruptcy, creditor law, whatever it may be. Different aspects of it will come into play. But I think what you said about my question is important for understanding the discussion. If I understand it right, then we are only talking about private for-profit trusts. That's what we're talking about, because we're talking about regulated trusts. We're not talking about unregulated trusts, which we already all agree that a data is an asset and can be put into trust. Unregulated, you're talking about a custodianship regulated trust, whether or not that should be, and whether or not it should be something we sanction, and if we do,
right,
how do we regulate it?
Right, Mr. Chairman, I think Joel has a point, but I want to follow up on your point as well after Joel.
Yeah, please, Joel.
Thank you, Mr. Chairman. Chairman Rothfuss, I wanted to address a couple of points that you brought up, and just it's good discussion, and just kind of further develop it. I think what you're describing is, do trusts as they're currently constructed allow for intangible assets like data or digital assets, et cetera, do we have the legal mechanism for that to be held in a trust? And I think the answer to that is yes. You know, it becomes difficult when it's intangible or difficult to value. But you know, essentially, a trust it's really a fiduciary agreement between a settlor that trustee will carry or hold title, and then at some point under some trigger event, will.
Joel, you're going on and off mute. Sorry to interrupt, Joel. You're going on and off mute. I don't know what's up with that, but we're missing about half there.
Yeah,
you're good now.
Apologies.
Thanks. No worries.
Should I back up a little bit? I'm not sure what was.
No, it was good. It was good. Please continue.
Yeah. Okay. So you're essentially separating your legal title from your equitable title, and you're giving that legal title to a trustee with instructions on what to do with it. That you need a beneficiary ultimately. And so can data and other intangible assets and digital assets, et cetera, flow through that mechanism? Yes. There may be some pain points right now with some of these, defining them and valuing them, but generally, yes. A data trust, as I understand it, and admittedly, my understanding is limited, has sort of a different purpose. And that is, just as an example, you get to the point where you say Facebook shouldn't have everyone's data and continue to profit from it. So you set up a data trust, the Facebook data trust, and that becomes a separate entity where a large group of people agree that the data can be held in that trust and not used sort of for profit by Facebook. Again, I'm revealing my lack of depth of understanding here, but I think what you're describing and what I understand as a data trust could be two different concepts.
Mr. Chairman, and I think they both are practical use cases or practical concepts, but I do agree that, yeah, the statutory structure for those two things are very different, and one of them would be focused on nonprofit. I was honestly thinking more of the analogy to what we do with a trust. That's not to say the other's not ripe for discussion. Maybe we'll have more interest in that area. I'm not sure. But I do think that there are some interesting use cases that are maybe challenges for how a traditional trust would engage a digital asset. And that use case is really the multi-key signatory concept, which is why I was asking about full relinquishment or how that ownership works, because what I can imagine being desired is I have a secret key, which I'm going to always keep as my secret key, which gives me full access to all of my digital assets. And we'll assume that it does include arbitrarily intellectual property. It includes cryptocurrencies, and it includes the pictures of my family. And that secret key will end up going to the grave with me. But I employ a data trust in this sense of I want continuity of my estate, and we establish a key ring such that you will have access as a co-signatory. So you might not have control, but you might have access. And then again, with electronic contracts, it's very easy to imagine a circumstance where if I don't use my key for a year or something along those lines, you've effectively got a dead man switch in place so that your key becomes controlling. So I would not necessarily be severing control or ownership in that instance, but I'm doing what is effectively the same thing by making sure that you, as the trusted third party, have the ability to then access and control it. And maybe that's not legally equivalent, because if I haven't relinquished my ownership to the trust, I mean, that might cause some, if you're thinking of it, property now, maybe that causes some property problems where I don't get the same protections that a trust provides, where the trust becomes the fiduciary of it. Maybe if I still have full control of it as I'm passing away, that it's my property and it goes to my estate. I think there's some rather crazy complexities here that might come into play, because those are real scenarios that will probably play out in the next few years, I think. Any thoughts on that? I don't know. I mean, we're just kind of exploring here. I don't know if anyone has anything to add there. And I know we have public comment also, so I don't mean to go too long, but I appreciate this discussion.
We actually don't yet, to my knowledge, have any public comment.
We do, Mr. Chairman. We've got Brittany Kaiser.
Okay, that answers the question. We sent her an email, but she hadn't responded yet, so maybe we just
I think
crossed
she.
wavelengths.
Oh, I put her in the room, but now she's gone. Hold on.
Oh, that also answers the question.
Teach me to take control of things myself. Okay.
That's all right. We'll figure it out. Okay. I'm sorry.
Mr. Chairman,
Yeah, Clarissa, please.
Brendan Marr also wanted to provide public comment. I sent him the Zoom information again, but I don't see him on the meeting currently. So just want to let you know.
Well, someone just joined. We've got Brittany back and we've got Brendan back. So now we're 2 for 2.
We do. Perfect. Okay. So committee, was there more discussion before public comment? Or do you want to we can move to public comment and continue our discussion. Ms. Kaiser, welcome. You were admitted, then booted and readmitted. But please, welcome. And feel free to chime in now on whatever you'd like to discuss.
Oh, perfect. Well, thank you, Chairman. Thank you, members of the committee, for having such a thoughtful discussion on my favorite topic and what I spend most waking hours working on, especially over the past few years. So for those of you listening that don't know me, my name is Brittany Kaiser. I am a data rights activist and global advisor on data protection, ownership, and monetization to both governments and companies around the world. So I think that this is one of the most important topics we could possibly be discussing right now, especially since after the slow implementation of GDPR across Europe, the EU has decided to adopt a European single market and use a data trust model in order to make sure that all EU citizens are able to consent and opt in to their data being held by a data trust, and the EU can negotiate as a single market in order to monetize individuals' data. Now, I suppose, why is this important? At a high level, the reason why there is a global issue around who is holding data and how that is monetized or not is because data has traditionally not been held safely, and it is very easy to abuse. Even if laws and regulations prevent certain use cases of data, we have not found viable models so far to make sure that you can retain your privacy on data sets that you do not want to be shared. But if you so choose to share certain types of data, under most legislative frameworks, it is difficult for you to actually claim the value of that. I don't think that is going to be the case for much longer. Over the next couple of years, and this is something that is already gaining massive momentum around the world with a lot of the governments that I'm advising, countries are moving more towards owning your data as a property model than hoping that that companies are going to be the best custodians of your digital assets. So what I mean by data ownership, just like in Wyoming law, where we say your digital assets are your intangible personal property, there are other states in the US as well as other countries who are moving towards that model, because data is now the world's most valuable asset. It is a multi-trillion-dollar industry that has surpassed oil and gas. And the way that we can alleviate poverty and be able to protect people's human rights is to allow people to own their data and the digital assets that they produce. As producers of the world's most valuable asset, taking a dividend of that could easily make sure that every person on earth could feed themselves and their families every single day at minimum, depending on what types of data you are willing to sell and how they are monetized. So this is one of the reasons why European single markets are trying to negotiate on behalf of all Europeans. This is the reason why countries like Mexico, South Korea, India especially are looking at these models, and especially in a time of COVID where there is massive unemployment across the world, and we're trying to look at, besides welfare programs, what would a universal basic income look like, just like the United States had to do this year with sending out stimulus checks to every American that had paid their taxes. So the idea of data ownership would be that that could provide actual monetizable value every single day that you could then make use of. Now, why do I think that a chartered data trust is the right model? There are quite a few reasons for that, actually. Now, I have to put out there that I am not an expert on trusts whatsoever, but I am an expert and one of the world's top experts on data ownership models and monetization. I sit on the board of over 10 different companies that have different business models that are related to the different types of ways a chartered data trust could work that you have just been discussing. And they're not all the same, but the general principle is as follows, which is that any of your data, whether it be personally identifiable information that could be used for digital identity purposes, or whether it could be pseudonymized or anonymized data sets that can be used and monetized in other ways, or if it is your digital content, you could be a content creator, an artist, a famous person that has plenty of digital assets that are easily monetizable, or you could just be the type of person who is an entrepreneur, business owner. You have plenty of IP, you have plenty of data that you either store on hard drives or in the cloud that is also monetizable and worth protecting. So right now, the current trust model, as well as the current data cloud storage models and big data vendor models, such as Equifax, which is an obvious example, Experian, Infogroup, Axiom, Labels and Lists, which sells our political data. These are all companies that are not regulated in a serious manner, and they are not regularly audited in order to make sure that we have basic cybersecurity protocols, proper data scientists that are working, that there are ethics codes being used by these organizations. So if a trust is to be a third party, because I think right now we have not a very digitally literate population. My Own Your Data Foundation in Wyoming specifically teaches digital literacy, so I am hyper aware that we cannot assume that most individuals and citizens are going to understand how to control all of their data and their digital assets and what decisions they should make for themselves of what should be shared and monetized and what shouldn't. So the idea is a third party that is trusted, that is chartered, that is audited, that is regulated, can be trusted with all of your data, digital assets, monetizable digital content, et cetera, and so forth. And they would be able to make these decisions on your behalf and also advise you on these decisions while carrying out the technically complicated work that it currently takes to both protect that data, make it monetizable, and make it shareable with on the global data markets, right? So as I said, I'm not an expert on trust, so I'm kind of agnostic on the structure. But I can tell you right now that I'm on the board of multiple companies that have started in Wyoming that would immediately apply for some type of license or entity if it were to be created, and many other companies that said they would move to Wyoming that are running one of these types of business models if there was something like this that they could apply for, because the marketing capacity and the trust that would give to their customers would be so big. So I would say that there's a specific list of needs that are required regardless of whether you want to move forward with a trust model or not. But I would say in order to replace both the big data vendors and data cloud storage models and even kind of agents that normally hold your hold your digital content, which is more for producers, famous people, artists, and especially interesting conversation of what happens to your monetizable assets after you have passed away. Then whatever entity it is, if it is a personal data trust, it needs to be able to hold your personal digital assets. And I've been talking specifically with many members of the committee, as well as Commissioner Fortner and Chris Land, about for the past couple of years about how we're going to define data. We're thinking more along the CCPA model, but if we're going to define data as property, or we are going to extend the definition of digital assets to include data as a type of digital asset, whatever way the committee decides to take that forward, it's still very important that this entity would not own your data or digital assets. You would have to retain full ownership, or this will never work. Giving up any ownership whatsoever legally is the opposite of what most customers of these business models are looking for. So that's probably most important. So they're custodians. They would have to have fiduciary responsibilities to you, because the big problem with most of the companies that currently hold our data is that they are only profit driven, and therefore they don't adhere to any codes of ethics nearly whatsoever. And they do not spend money on cybersecurity protocols or advanced data science that will protect your assets. They are more interested in making money for their shareholders, and that has caused some of the biggest global disasters in the past many years. They would, and besides preserving ownership, what they would have to do is help you protect that data and help you monetize it, and to understand the difference of that. So you're probably going to want to protect intellectual property or personally identifiable information that can be used for digital identity. But all of the data sets or IP or digital content that you could monetize, then they would help you do that as well. For instance, I'm on the board of one company called Rainfall. It is a blockchain company with a digital wallet where you can decide what data of yours you want to monetize, and they hold your digital identity data safe, but all the data that can be pseudonymized or anonymized, they model on top of that, and model data is worth significantly more, especially when it's modeled for particular industries and particular purposes, for advertising or medical research, for instance. Then that creates an exponential value on your raw data that can then go into the market and create much more financial value for you on a marketplace than it would be raw out of your devices, which is how it is currently collected and taken from us, from companies. The next would be, there would have to be minimum requirements for cybersecurity protocols, audits, the level and skills of data scientists that are working at this organization. They would have to have the option of you holding your keys or them holding them for you, depending on what customers were most comfortable with. And yes, of course, continuation past your lifetime, or being able to ascribe that value to your family or loved ones when you are no longer with us, is definitely something that is incredibly important as well. So sorry that was a little long, but I think I covered enough, and I will leave it to any questions that you might have. Thank you.
Questions, Joel, please, Mr. Ravel.
Thank you, Mr. Chairman. Thank you, Ms. Kaiser. That was very helpful. What you've just described to me sounds a bit more like custody as opposed to a trust. To me, the purpose of a trust is for the kind of intent to transfer something to someone else. And as you were describing it to me, that's sort of the last thing that we want to be that you want to happen. That you're giving up the title, you're giving up control in order to pass it to get in exchange for that some benefits. Whereas custody is, sort of the safekeeping, regulated safekeeping of assets. And so is that, am I right in that? Thank you.
Yeah, thank you. So what's interesting is that you kind of need to have aspects of both, because you would be protecting certain data from being accessed at all, more through a digital identity standard. And then you would also be transferring certain data to other entities in order to monetize it. So on the technical back end, the way that this would look is certain data would be completely shielded and be part of your digital identity. And then you would have an API where any companies on the global data market or organizations that were interested in licensing that data or purchasing it or whatever model you have consented to, then that could be transferred to other entities and you would receive the value back for that. So it would actually do both, which is why I said I'm agnostic as to what the entity would look like in the end.
Mm-hmm. Thank you. Thank you, Mr. Chairman.
Thank you. Senator Rothfuss.
Thank you, Mr. Chairman. And to Joel's question, it's really interesting because honestly, it's sort of halfway between the two concepts. And I think that's one of the challenges. And maybe that's why other states haven't cracked this nut, because it acts like a trust in many ways. But then at the end of the day, as Ms. Kaiser pointed out, you don't want to convey ownership of the data. You want the data ownership to be maintained by the individual or entity that is the data source. And I don't know that there is anything in statute that behaves quite like that. We want a lot based on the description. You're most of the way there if you had a model that was analogous to a chartered trust, state chartered trust, except for that ownership aspect. You still want a fiduciary responsibility, so that's consistent with the trust. And then you could obviously regulate and audit to the standards as suggested, so that at that point you can have confidence in it. But Mr. Chairman and Ms. Kaiser, we've got another analogy that I'm reminded of are these chartered family trusts that we have. Regulated chartered family trusts, because even though they could do it all privately, they could have a private family trust that accomplishes what they're looking for. What they want is they want the regulation because they want the third party oversight. And what I'm kind of understanding, Ms. Kaiser, from your testimony is that there would be tremendous market value to having that oversight, because then the users, the consumers, could have more confidence. And we all know what happened with Equifax and others. And all of my data was stolen from OPM years ago. So a lot of us have had plenty of our information hacked over time. So, is that correct? That seems to be where the value is. And if our objective should really be focused on providing that additional level of scrutiny as kind of the key to this concept.
Yes, absolutely. And I'd like to give an example of that. I was right before COVID shut everything down. One of the last conferences I was speaking at, I was in Sweden, speaking at one of the government-sponsored cybersecurity conferences. And what I found out was that the government actually issues a cybersecurity certificate that shows that you are a qualified company that has certain cybersecurity protocols and regulations and skill sets within your organization, that you are a trustworthy custodian of data from the cybersecurity front. And that was the first time I've ever actually seen that. And the company that was the main sponsor said that once they got that certificate, they had a flood of customers coming to them because they were one of 3 companies in Sweden that had this particular certificate. So they were trusted, and therefore all these customers came to them for their data science services. And that's what I'm really looking for in the United States, where right now we're not anywhere near federal legislation for data protection. We only have it in the state of California, and it's not even comprehensive. And there's just so much to be done, and so much momentum and so much interest that should one of these new startup companies or growing SMEs that are working on these business models choose to go this route, they would quickly become the leaders in the market. And I know not just the companies that are my portfolio companies, but the companies of many of my colleagues, friends, fellow campaigners who usually testify federally on these topics would immediately start pursuing that license.
One quick follow-up, Mr. Chairman. Well, along those lines, GDPR and CCPA, it sounds like California doesn't have in place something of this type. So although they have CCPA in place and they have some rigorous requirements for data protection, they don't really have anyone, as I understand it, then necessarily providing the certification that this company is achieving data protection. So from that standpoint, it seems like there's actually a ripe market where if we were providing the auditing and the appropriate regulatory structure, and it achieved CCPA style, sign off, so to speak, so that we could actually be capturing the value of CCPA effectively in Wyoming, because they'd come organize here, they'd be regulated by Wyoming, but then they'd be operating on California data so they can adhere to CCPA. Do you think that's a fair potential approach?
Absolutely, and this is something that I talked with Chris Land about last week. I'm often in touch with Alistair McTaggart, who wrote CCPA, and he wrote Prop 24, which is the update to it. And so, he'd be very happy to advise on how Wyoming can write CCPA compliant legislation if we're looking at data trust or definitions of data here in Wyoming. He helped us with the New York Privacy Act, which still hasn't passed, but is in its 3rd iteration in Congress, that I helped write the next version of last year. And so there's second mover advantage, which I think I've had conversations with quite a few of you of the advantages of that, where CCPA, has been difficult to implement for California. So therefore they have an immediate update, which is Prop 24, and hopefully it goes through in November. But we can look at everything that worked and what didn't work in California and have second mover advantage to write a similar and easy to reconcile between the two, but something that is improved and actually has a business model attached to it. California has now kind of a California privacy agency, and what Prop 24 does is enables that agency to have at least $10 million to start and 50 staff that help with CCPA compliance. So they are creating an entity, a body within the state that is there for companies, and perhaps that is the type of body that would be, the regulatory body or auditing body Also something that I should note on that point, which is that last year, a number of legislators dropped a bill in federal Congress to propose to start a federal U.S. data protection agency, which I 100% support. I just have no idea when that's going to go through. So right now, state by state entities for regulating this industry is probably the most practical step forward.
Great, thank you. Appreciate that. Thank you, Mr. Chairman.
Well, thank you, Ms. Kaiser, for your, Representative Lindholm, please.
Thank you, Mr. Chairman. Ms. Kaiser, thanks for joining us once again. You've been a pretty integral part. You were there the first year I filed these bills, and then all of a sudden, like, all these people showed up, and I was like, who are these guys? We must have done something right. So it was really good to see you here, still involved with Wyoming. Thank you for being here. In regards to, I mean, here's my hesitation, Ms. Kaiser. By defining what can be held in trust or what can be held in any way whatsoever, we're also going to be defining what can be taken by state or federal government within the state of Wyoming. And I have real serious hesitation there, not because I'm not a law and order type person, it's just I don't trust my government. So can you, I mean, you probably understand the hesitation there. Can you speak towards that?
I can definitely speak towards that. And
I'm sorry, Ms. Kaiser, are you speaking towards Representative Lindholm's distrust in his government, or?
Yeah, actually, that's what I was going to address first. I think now more than ever, a lot of us feel that way, but the blockchain industry came out of people that felt that way. So the reason why a lot of these technologies exist is so that we can own our own assets and own our own value, which is why I said any entity that would be custodians of our digital assets we would have to retain full ownership over that legally, or it wouldn't be of interest. So again, I'm not an expert in trust, but can you explain quickly under what circumstance the state or the federal government would be able to take your assets if you own them out of a trust?
Representative Lindholm, can you answer that question?
Yeah, thank you, Mr. Chairman. You know, I'm not an attorney by any stretch of the imagination or anything like that. I just hesitate to define anything as far as what can be held, because at that point, once it's defined and once it's put there in statute, that means that it can be taken. So in regards to a trust, if wrongdoing is suspected and it's in concert with a trust, at that point, can it be taken? So I guess that'd be a question for maybe the attorneys in the room. How would that work?
Any attorneys want to weigh in there? You're itching, Senator Nethercott. I see.
I think you want to answer it. Senator Nethercott, that's written several pieces on digital privacy.
Yes, Senator Nethercott, the author of many of our bills, please.
The question is, how does the government get to your trust assets? Like they would any other asset? So, you know, it depends on the type of action. If it's a civil action versus a criminal action, you know, they just would target the trust for the asset. So just like, you know, a trust works similar to a corporation. So just because you have a corporation doesn't mean they can't get your corporate assets, right? So it's just the same concept.
Thank you. That's very helpful, because I think in any situation, if you have committed crimes, we're looking to never be making an entity that is helping protect criminals. So if criminal activity is the only reason why the state or the government could possibly take your assets out of a trust, then that doesn't concern me.
Representative Lindholm.
Yeah, thank you, Mr. Chairman. I can't help it. Politicians, ourselves, and well, the people in this room are really, really good people. People define what's criminal activity. And over time, we have gotten that wrong numerous times. And so that's why I hesitate on this whole digital trust aspect, or the digital identity within a trust aspect, is you're putting a whole nother level of assets, in my opinion, under the target. And I don't break the law or anything. I mean, not more than I have to, but.
So if I could address that quickly. So right now, all of the assets that we would put into a personal data trust, we are currently trusting with Apple, Microsoft, Equifax, Facebook. I mean, I could go on, but those are our custodians right now. And actually, they're not custodians because they just take our assets and keep most of them for themselves. We no longer retain any ownership. That's the situation we're in. So anything better than what we have now, I think, is a step in the right direction.
Representative Lindholm.
Thank you, Mr. Chairman. And I don't disagree, I guess, with the ideology that this could be beneficial, because I certainly don't trust those entities you named either. But the biggest difference is in the state of Wyoming, there's no definitive aspect in law, because as soon as we define it in law as far as what can be in there, then it can be taken. As of right now, it's not defined. And so it lives a little bit in this gray area where I guess I have more trust in the gray area than I do. And this is a divide right here in this committee, because I know this committee's pretty split on this subject. As Senator Nethercott side-eyes the whole committee. It's one of those differences of opinion, and I think it's an important discussion. It's as important a discussion to have as any other topic we've had, just because it's becoming a major issue.
Chairman Rothfuss.
Thank you, Mr. Chairman. On Representative Lindholm's point, honestly, I don't know that I understand the difference or how we're in a gray area that's more protective now, and what would trigger something different, because I don't think we would define what's in a trust necessarily. I think we would just say there is a trust. It has the capacity to protect data to these standards, and really any data could go into that trust conceptually, at least from the statutory standpoint. So I don't see how we would necessarily know what's in the trust without looking in the trust and having access to it. And maybe that's the concern. But then the other, maybe the concern is if we're calling it property, it then, or even intangible property, that then it has some sort of standing that leads to it being taken, so to speak, by the government or queried by the government. So I'm asking Representative Lindholm for more clarification, because I don't think I'm seeing the nuance of his argument.
Representative Lindholm, please clarify.
Yeah, thank you, Mr. Chairman. I would bring to example a piece of legislation that the good chairman co-sponsored that kind of kicked this whole thing off, ICOs. We defined what a utility token is. We defined it very heavily. And because of that, we've had security tokens come about in the state of Wyoming. And not that we're against security tokens, absolutely not. We never defined security tokens, but by the simple definition of utility tokens, everything else was security. And so in that same vein, by the simple definition of what can or cannot be considered personal identity or personal data, we define everything else as not being, and thereby, in my opinion, is the problem. Are we going to get it 100% right? Who's going to suffer? And so that's.
We lit a fire now. Everyone wants to.
Yeah, please, Senator Nethercott.
So while I was listening to the discussion, I was looking at the New York Privacy Act and the current piece of legislation in there, and I think it doesn't look like it will probably be successful in light of the heavy hitters that are against it. But I wish them luck. Interestingly, one of the concepts in there that the industry is railing against is the private right of action to sue, which is fundamental and constitutional and part of our liberties. Don't forget, we like to obviously do that. But an interesting way, Representative Lindholm, if you really want to create chaos, is to put in Wyoming statute some type of dollar figure associated with Wyoming citizens' data and let the plaintiffs' lawyers teach big corporations what money's really about. And that's how we really do effectuate change in this country, actually.
$1 million
Wyoming-
per instance.
And in Wyoming, that sounded actually very Spence-esque. I feel like the great Jerry Spence on his
It'd be-
when he ran for governor, that was one of his talking points, actually.
Simple, artful, and effective.
Ms. Kaiser, please.
Thank you, Senator Nethercott. I'm so glad you brought that up because that's where the first state where we have case law where you own your data as your property is in the state of Minnesota, where I was the only expert witness in the first successful case against Equifax, where we sued them for property damage for the data breach. And in order, we did this through a new concept that the lawyer I worked with invented called mass tort. And so we kept the price per person to under a certain amount. And we actually estimated that the minimum value of the data breach to every individual was kind of a lifetime subscription to fraud protection. And so that was however many years on average of fraud protection minimum as a value point. And we had 500 people sue at the same time in a municipal court, got kicked up to jury and then up to the Supreme Court, and we won. So there is one state where you own your data as your property because of that precedent. And that's exactly what we did, was ascribe that dollar value to the data breach without saying that your individual data point or a data set is worth that money, but the damages caused to your property through a data breach are worth at minimum the value of needing to have fraud prevention for the rest of your life.
Senator Nethercott.
Yeah, so I just want to kind of qualify some of my comments that some, I am kind of, just throwing ideas out there for purposes of reaction and discussion, but these are interesting, really, concepts. So in contract law, when damages are indeterminable or might be too hard to be determined, the parties agree to what are called liquidated damages to a set sum for the value of the contract for some type of breach instead of having to determine actual loss. So these concepts are well within our law to have a dollar amount. And another kind of concept that dovetails into this that we're familiar with in our laws is defamation and slander. So what is one's reputation worth? Really, what is it worth if it's damaged for a lifetime, if it's damaged from a business opportunity? And so those are really difficult to also assess, but it's a similar concept that we are, I think, needing to get our arms around here for what are the consequences to some of these large entities that are profiting without our consent off of our data, and in a way that may be harmful to us that we know or don't know. Right. And does that matter? And is there a way to hold them in check? And we know that the only way really to hold corporations in check who are profiting off of this is to make sure they have to pay. Right. I mean, the only way to hit home is with money. And so, I love to make felons, as everyone know, and I love, prosecutions. But the truth is the value of this is in the money. Otherwise, the prison sentences in a federal prison are just going to be the cost of doing business for a couple of years before they just go sell billions of dollars worth of more data. So I really think that's the source of it.
All right. To quote Senator Nethercott and move this along, this is a great discussion, not to short-sight it, but it is also getting pretty deep here. So.
And Mr. Chairman, we've got two more public testimony, Mr. Marr and Ms. Reyes.
That is exactly where I was headed. We got some more public testimony that I want to invite in. So, Mr. Marr, please. Brendan, you're muted. Aha.
Wonderful. Can you hear me now? Wonderful. I'm Brendan Marr. I spoke earlier today. I'm a Media Lab alum from 1998 and part of the MIT computational law ecosystem and community. I would like to speak to Senator Nethercott's revolution, because I think it's important. And I want to shed a little bit more light on how we can think about these things. What I would stress is that the idea of a trust is a very good one. For a little bit of background, I do have a fairly deep understanding of statutory trusts, both in Delaware and in Wyoming. And I would like to say that trust would be good for many reasons, but not necessarily in the way that you might think. And it has to do with this. The first question is, how many passwords does everybody have? I think at a minimum, we all have, at least 10, maybe 50, right? What we're seeing in the community is this, and it is related to how data is stored and how it is distributed. So currently we understand data to be this thing that lives in silos, as Brittany has expressed, but we're moving into a decentralized world where the data is decentralized and spread over many, many different systems. And I'm not just talking about, like you have a Microsoft Word document that's sent to another computer. Take Senator Nethercott's name, which I counted the big 10 characters, which in this example, those 10 bytes get spread out over 10 different computers. So what we're seeing, and the transformation here at the underlying fabric of this new internet, Web3, is that data is going to be distributed just like we have with HTTP as a file format. We'll have file formats that allow for data to be distributed and encrypted and spread out. So this idea and notion that, first off, that the European Union has, that they're going to contain data in one geographic location, is completely at odds with how computing works. Can you all see me? I think I lost the video feed. Oh, am I there?
Brendan, you're muted now, but we can see you and we could hear you.
Oh, great.
We've got you.
I'm
You're perfect.
not exactly sure where I left off, but
We somehow lost the chairman. That was part of the problem.
Okay.
He vanished. But
I'm back. I think maybe it's the view you have. Maybe if you only have me, it looked like I was gone, but.
well, I wanted to speak to Chairman Lindholm's point, which I think is very, very important. And one of the ways to think about these trusts is that, first of all, they don't have to store all the data, right? In the regard that we're talking about, they can do that, but their primary function is also for storing keys. And it doesn't necessarily have to be one trust, right? We have multiple signatures. We might have different trust entities. Going back to the password analogy, what we want to have happen is a way for people to easily have multi-signatory wallets, and in some cases have these trusts be one of the parties in that multi-signature wallet to have control as a multi-signature party. So not full control, but just partial control. And these things should be cheap and easy to set up. I mean, I should be able to set one of these up, just like $5, and I've set one up, and I can let that trust have control over those keys, and that's fine for certain kinds of transactions and certain kinds of wallets. It's what we're going to see is many wallets, right? We think right now in terms of, okay, I have a Bitcoin wallet or I have a Ethereum wallet or whatever, but there's going to be many different kinds of wallets, because the idea of a wallet now is becoming one in which it is actually a combination of a software interface and access to a blockchain. So it's actually becoming a chunk of software where the user will sign in, and when they sign in, that private data will be distributed on a chain, and it will be independent of these wallets, but it will be accessible in a way in which the data is separate from the keys and the wallet functionality. I could expound upon that more, but I don't want to get too far down this trail here.
Thank you. Appreciate it, though. And Senator Rothfuss.
Yes, Mr. Chairman. Mr. Marr, I appreciate those comments because I think it is really good for us to understand that with the technology, there are a lot of options and opportunities that don't just mean, you know, putting all of your data into one honeypot. If you have a good structure and if you're just basically looking for appropriate ways to store keys that are then access to things held elsewhere, you can achieve a lot of the objectives that we're talking about without necessarily having to have repositories. And I think there's a lot of value to that. So thank you, and we appreciate your participation on that.
Thank you.
Okay, I think we have, well, we lost her.
Nope, she's here, Mr. Chairman. I see her. You've lost her.
Oh, I've lost.
Yeah.
Carla.
Hi, so I'm
Please.
Carla Reyes. I'm an assistant professor of law at Southern Methodist University, Dedman School of Law, and I actually have come to you quite late to the game, I think, but I just wanted to comment. I've looked at business trust in the context of blockchain technology quite extensively, actually, and I find them remarkably useful tool for many things in the context of blockchain technology and perhaps data more broadly. But I would like to point your attention to a couple of both national and international level projects that are looking at some of the core questions you're talking about right now, including the first of which is data generally property? And if so, how? Is it property within the rubric of digital assets? Is it a subset of digital asset, or is digital asset a subset of data more generally? So it's just worth noting those discussions are just starting, both at the Uniform Law Commission and at Unidrat. In Rome, they just actually held 2 days of discussion on that topic specifically at the end of last week. With regard to Unidrat in particular, it's worth noting that there are a variety of jurisdictions where data simply can't be property because they don't recognize intangible property, for example, and it's completely contrary to their formal legal principles. So to the extent that we're imagining a worldwide operation, the type of distributed computing that Brendan just discussed, you might run up into difficulties, right, with some other jurisdictions to the extent that you can follow along with those discussions that might be useful research and input into your discussion. With regard to the trust, particularly, I found the idea that you just have to hold the keys particularly helpful from Brendan just now. But I would say the piece about you have to turn over your rights, your ownership interest to the trust, that's right? What happens, you turn over your ownership interest to the trust, you get in return essentially a share, right? Because it's a for-profit trust. And so you get in return your trust certificate, which entitles you to a variety of things. One, the trustee has to oblige by fiduciary duties, which are notably slightly different in the trust context than the corporate context, right? But nevertheless, fiduciary duties. And then you are entitled to a return on what's essentially your investment, just like in a corporation. So the question becomes, is your interest in the trust as a policy matter in part to enable the person to partake in the money-making enterprise from their data, or is it just to protect their data? In which case the custodian model might be more appropriate, right? Entirely depend on the policy reasons for your approach. But lastly, to the point of how can your stuff get taken from a trust, it might be instructive to look at the original business trust, the Rockefeller oil trust, right? How does it get taken away? Well, an antitrust suit, right? Antitrust comes directly from trust becoming too big And notably, there's already lots of talk about how we might look at antitrust actions against information intermediaries. Lastly, I just note that there's quite a lot of scholarship, particularly coming out of the Berkman Klein Center, around the possibility that enabling all data to be monetized or commoditized might not always have beneficial effects. And so there's some literature questioning sort of the ripple effects of what happens when all of your data is actually property, and what ecosystems and economic models around selling your own data might actually end up looking like. And it might be worth bringing in some of those experts from Berkman to discuss that literature. That's all I really had at the moment.
Senator Rothfuss.
Thank you, Mr. Chairman. Ms. Reyes, how do I say your last name? Is it Ms. Reyes? Is that correct?
Yep.
Okay, great. Ms. Reyes, first of all, thank you so much for joining us kind of a last minute and being willing to participate in this discussion. Obviously, this is something that a lot of governments, a lot of states, a lot of people, academics are wrestling with, trying to get this right. I think you raised a lot of the concerns that we've been challenged with on digital identity, on contemplation of data as property, how much of it's property, how much of it should be, I'm going to use the word propertized or something like that. But the idea of how much of it can we buy, sell, and trade, and how much of it should be intrinsic, that's a discussion that Christopher Allen points out frequently when we engage with Christopher, the idea that maybe not everything should be sold. Maybe there should be some intrinsic identity related information, and bringing all of those things together. So I think you raise a lot of challenging points for us. And a couple things that as we're working on this, first of all, if the Uniform Law Commission has started working on it, one of the things we like to do is to draft laws before they have a uniform law that's contrary to the direction they go. So if you could help us with that, that would be great. It would make Representative Lindholm a lot happier if we would go in opposite directions from them and then just get it done first. So thanks for that. And
that might actually get me in trouble, but okay.
Great. But along these lines, the concept, and I think you were listening to the discussion that we were having. You pointed out the trustee or the trust versus custodianship concept. And we were having a little discussion about how with data, it's almost a hybrid, because as Ms. Kaiser mentioned, you don't necessarily want to relinquish ownership. I don't want someone else to own my identity or the personally identifiable information about me. I want that ownership to be maintained by me, and I want someone else to custody it and act as if they're a fiduciary, but because they have joint signatory capacity, as opposed to because I have truly severed ownership. And I don't know quite how to do that.
Right. So unless you want to create like a new trust category, that's not the statutory trust, like it would need its own thing, right? The existing model wouldn't work necessarily, but there's some suggestion, at least in light of the recent case about the private keys being held, right? When your Bitcoin forks, for example, when the protocol forks, that even a custodian has your keys, that's more than just custodial rights in some regard, right?
Right.
So even then, maybe you need to outline it a little bit more distinctly for what you have in mind. I think when it comes to issues about whether data is property and this idea of custodian versus ownership, et cetera, more broadly, what at least my international colleagues tell me they worry about the most is the ability to exclude, right? The power of exclusion and the very easy replicability of most data. So when you're not talking about blockchain-based data points, but at one point in your discussion, I heard photographs, right? Things that can be quite easily replicated in the normal course of things. In particular, if you don't just look from the consumer side, the person who owns the data, but then the folks in the custodian's role or in the trust role, it'd be quite easy for them to be accused of misusing or losing your data when what really happened was unauthorized replication of the data, for example. So those are some of the broader discussions that international folks are having.
Good points. Thank you very much, Mr. Chairman. Thank you very much, Ms. Reyes. Is it Dr. Reyes? Is Professor Reyes?
Miss or Professor is fine.
Professor, good. Thank you.
Representative Lindholm.
Thank you, Mr. Chairman. A little inside joke there. So first of all, I'm really impressed by this conversation. I mean, the reality is the more we delve into this whole deal, I think it's becoming apparent and obvious to everybody that a traditional model, whether it's in qualified custodianship or it's a statutory trust or anything like that, is not going to work. I think everybody kind of recognizes that. And if it were to work, we'd have to really kind of modify some things to make that a thing. And so I guess for Ms. Reyes, Reyes? All right. Okay. Sorry. I'm a cattle rancher in Northeast Wyoming, so you're gonna have to forgive me. In regards to how that would work, I mean, since it would essentially need to be a new thing or a new type of thing, would you prefer a new type of trust or prefer a new type of custodianship? Because the reality is we could do custodianship like a qualified custodianship, really. So I'd be interested to hear that.
I think that entirely goes to your policy objectives. If you want the original owner or creator of the data, the person, the consumer, to be able to participate in the economic sort of surplus or benefit of the use of their data, then probably some other kind, like a subspecies of a statutory trust, right? A for-profit business trust. But if what you want is just to keep their data safe and continue to let other companies profit off of it, right? Separate, it's not, and they aren't diametrically opposed objectives. You could also want to keep people's data safe while they also profit from it, right? But this piece, do they get to profit from it themselves versus just have a safe place to store it? Those aren't exactly in line. And once you've made that decision, I think custodian versus a subspecies of a trust is quite easy. You'd want the subspecies of the trust that would allow them to be part of the business model.
Mr. Chairman?
Yeah, co-chairman, please.
Thank you. Professor Reyes, I think we want both, though, because I think we can't predict what the business case is and what the useful business case is. I think we clearly want the opportunity for someone to participate in the value of their data, that concept and that model. And we want them to be able to choose not to participate in the value of that data. We want them just to be silent if that's their approach, so that they might have their information stored, but they don't want anyone else to be able to have access to it. We want concepts which are more like a traditional trust, where I have valuable assets that I want to pass on in a similar way as a trust to future generations, for example, by utilizing a trust structure. I've got my intellectual property, I've got my awesome music and songs that I've written over my lifetime that I want to preserve for posterity and make sure that they're appropriately monetized by only my family, all of those kinds of things. And it's when we're doing this, one of the things that we focused on, I think, in recent years, as we're looking at these innovative spaces, is to try not to predict what the business plan is going to be, and to try and put in place a framework and a structure that is a wonderful Swiss Army knife of opportunity that allows us not to have decided that it's just the use case that we were contemplating. So I don't know how to get there. And I think that's where we're trying to get, is how do we set up a structure that does that?
So you might do both then, right? You might enable custodians and a subspecies of trusts where the custodian isn't in the business of making money off of your data by putting it to other use, but a trust would be allowed. Sorry, my lights go off if I but you would be able to put your data into a trust and make money off of it, even passively, right? Typically the statutory trust, you're just a shareholder, the equivalent of a shareholder. So it doesn't mean you have to do anything with it. You just give it to the trust and let them make money off of it, but then you get the benefit of it. So there's no reason you couldn't do both, right? And say, depending on what you want to do with your data, here's two options for structures in which you could place your data for safekeeping. I'd also say that things like what I'm told you're about to look at, smart contracts and things like Lexon along the smart contracts would enable people to be more confident in the way the trust is behaving with regards to their data, right? So in particular, if you don't want it to be used, stick that data in a smart contract, right? And make it be stuck there until you give your authority or whatever the triggering event is to be further processed and used. And particularly if they are readable smart contracts so that the consumer can know what is going on, that's all the better. But I don't think you're limited at all to one or the other. You could always create a statutory scheme that has both.
Thank you.
Joel, welcome to the conversation.
Yeah, thank you, Mr. Chairman. And great conversation. Thank you to Ms. Reyes as well for the contribution to it. I feel like we're spending a lot of time trying to figure out structures when really I think the art of this is defining the asset.
Yeah.
And I think if we properly define what data is and the rights associated with that, then it's not much different than what most of you in our predecessor task force did with digital assets. You define what the asset is, and then there are all these mechanisms through which that asset can be protected or monetized or passed. So a lot of what we were talking about earlier is just simply custody. That would just be considered data as an asset, and you have a regulated and audited custodian who has to abide to a certain standard to protect your asset, i.e. your data. If you want to pass that data to the control of a trustee or a board of trustees, whether it's a corporate trust or a public trust, then that's your prerogative. If you want to sell that asset to a corporation and profit from it, if you want to invest that data in a corporation, if you want to form an LLC with that data and profit from it, all these mechanisms and structures, I think we're kind of getting lost in that when they already sort of exist and their purpose is quite clear once you know what the asset is. And I think the art is defining the asset, and as you all worked so hard to do previously, tie that back to your commercial laws or personal property, whatever that might be. Thank you.
I don't know if I can respond just briefly. I think that's absolutely right. And I think it goes to the core issue, the one I started with and said everyone's looking at this right now, which is data, broadly speaking, not just digital assets, like based in blockchain technology where you can exclude people, right? Because that's what the technology is for. But is data, broadly speaking, your Facebook data, your photos, things that are easily replicable without additional layers of something put in there, right, to make it not so, is that stuff that can be considered property, right? Because you don't have the power to put the fence around it, to hone in the commons, right? At the basic, like, first year property law class, the one we all try to forget. But sorry, property law professors. But that's the issue, right? That people are really struggling with, in part. Yeah, that's the one everyone's struggling with. And in part, if we do go with that, with a broader understanding of what data is property, what happens to the existing definitions we have about digital assets, which didn't necessarily contemplate that? I know yours is different than the one from the uniform fiduciary access to digital assets, for example. But what happens when you expand the definition in that way?
Eventually,
and could it
they'll
actually
come
be more harmful than helpful is the real question.
Ms. Long.
Thank you, Mr. Chairman. First of all, I wanted to underscore Professor Reyes has been extremely helpful in the working groups on which she and Chris Land and I are participating at the Uniform Law Commission to try to move them in the right direction. And thankfully, they are now understanding blockchain technology a lot better, in no small part thanks to Professor Reyes, who does understand it and is helping to advance the ball. And not surprisingly, it's moving toward where Wyoming ended up, which is good for us. But my question on this particular topic is, will we open up a can of UCC worms if we actually start to create a whole new asset class called data and start to put it into a new kind of trust? Are we just biting off something that's just a very, very, very large thing to bite off? Thanks.
Yeah,
Is that a question
and that's
for
where the
Professor
uniform.
Reyes? I'm sorry, hold on, Professor.
Yes. Oh, yes.
I want to hold on. That's a question for Professor Reyes. Okay.
Yes, Mr. Chairman, thank you.
Professor, please. I'm sorry.
Sorry, I didn't know the protocol.
You're
So
okay.
it was a great question, and it is the one the Uniform Law Commission is focused on, and UniDROT for that matter. Because so say you'd say all data is property, and you can put it in the trust, and say it's a statutory trust that wants to make money, and part of making money is getting a loan. And normally you take your assets and put it up for collateral. Right now, does that fit within the existing frameworks that we have, particularly for intangible assets, which are focused on control? Right? So can you perfect via control something that you can't exclude others from readily, right? That's why the exclusion piece is so important, particularly for commercial law folks. And it's what we've sort of been rolling around and around and around at both UniDROT and the Uniform Law Commission. Yeah, it's a great question.
Mr. Chairman, follow up?
Yes.
May I ask Professor Reyes, where do you think this should land? Have you formulated a view yourself?
So I don't know I hope this doesn't get me in trouble. I think I do sort of have a view, and I think it's one, well, so we have this working group that meets once a week, right? And it's one where I think that's where we're headed. But generally speaking, we at the Uniform Law Commission haven't defined digital assets yet. Like, we've kicked it down the line, really, because it's this big question. And what we've said so far is, let's assume it's digital, it's data that is subject to control. And then let's figure out what control means and how flexible the control piece could be. And then whatever fits in that is a digital asset. So far, that's as far as we've gotten. But I think that's quite, like, if control, if that exclusion piece, what data can be, even if it's enhanced with smart contracts, with encryption, whatever, what data can be excludable, or either naturally, sort of in the, I hate using this term, endogenously, be made subject to exclusion, or can we make it excludable in some way? That's the stuff that I think of as digital assets that should be property. It's because the rest of it is going to cause a bunch of problems that I think it should be outside. That doesn't account for all of the issues that Ms. Kaiser was discussing, I think, which to your policy objectives, right? That's one of the things you all will have to wrestle with, I think, because that my own definition, my own view is not the same thing that would fit everything Ms. Kaiser was discussing.
Senator Nethercott.
Thank you, Mr. Chairman. Just kind of, so this topic is so important, and one that I think that we need to continue to work on. I think it'd be helpful for the committee, because I am hopeful that we will be able to produce something, if not this year, next year, to narrow down based on what Professor Reyes just said, and what we've heard from, one of the global experts, Ms. Kaiser, on the topic, that it's very large, right? And so I think we need to break it down into what problems we are trying to solve. Like, so my comments earlier, were really focused in on kind of my, anger, I guess, at the misuse of my information, right, that I don't consent to, and how that is all being calculated and used, and Lord knows if anyone even cares. And that's the only comfort I have, is that no one really probably cares, but I do know it's being used, right? And all of our data is being used. And I wish I knew, and I wish I had more control over that, because I don't have a choice not to live in a digital world, right? That's not a choice anymore. And so even though I have to live in a digital world, I'm not consenting to the misuse of my information. Now, when we talk about what Ms. Kaiser talked about, which is the monetization of my information, how interesting is that? And then that triggers into, I think, the data trust is the monetization of the data, but kind of separating out the two issues of the misuse of data as opposed to the monetization of data. I think we might get different results there and different solutions for each of those pieces. So I would ask the committee to kind of take this issue, divide it into, and maybe more, but big picture, kind of those two pieces. I think they're both equally important.
Representative Lindholm, what say you?
So I guess a couple things. I guess, first of all, when it comes down to the Uniform Law Commission, that wasn't me that pissed them off. That was Senator Nethercott. Senate File 125 was her baby. I had nothing to do with that. Voted for it. That was it. It was a good bill. Second, I don't know what endogenous, I'm probably mispronouncing that. I couldn't even look it up to see how.
Self-causing.
Okay.
There you go.
I couldn't spell it to look it up, so I'm glad that was shaken out. But more importantly, Ms. Reyes, do you have say like a sketch of an idea of what this definition might look like? I mean, would you be willing to work on that, I guess, would be the better question.
Yes, I would be willing to work on it. No, I don't have an existing sketch. And I do think very strongly that to Senator Nethercott's comments that I think it will depend on what your policy goals are, and that you might end up like, there's no reason why. Yeah, I think you should keep your policy goals in mind, whether it's one or both of the ones that she described as you define the term, right? So the commercial law people might be concerned about very different things than folks who are worried about the misuse of data more broadly, right? Yeah, but yes, I'd be happy to.
All right, Representative Lindholm.
Thank you, Mr. Chairman. That answers a big question for me, and I think I speak broadly for the state of Wyoming and the legislature when I say privacy is one of our largest concerns, or one of our larger concerns. Most of us, anyways, feel that way. And I will have a motion once we're done, Mr. Chairman.
Okay. Very good. So far, we've enlisted Professor Reyes, and we may have a motion. We believe we're going to bifurcate the topics as we begin to move forward and hone deeper into monetization and public protection trust. Committee, any other questions for our public commenters?
No, Mr. Chairman.
Senator.
Thank you, Mr. Chairman. I just want to thank them. I don't have any more questions. I think we probably have a lot to think about here, but we really appreciate this discussion. It was exceptional. Gives us a lot to think about and work on. I think we need to refine and focus down what our policy objectives are, and basically just put them on a piece of paper as bullet points. These are the things we want to accomplish, and then we need to figure out how we accomplish those things. And I think Ms. Kaiser gave us a list of several of those things, and we can add to that list and effectively determine what path we want to go forward. And then we would appreciate continued involvement from both of you and our other stakeholders on trying to get there. So thank you so much for joining us today.
Yeah, and I'll echo those sentiments. Thank you. I don't know if you were listening before lunch, but before lunch, Senator Rothfuss said this was going to be a quick topic. We didn't have much to say, which may have been true as we started, but once the two of you entered, we really got going, and I think we're onto something now. So do appreciate all of your input. Thank you. With that, committee, we're only a couple of hours behind schedule. Oh wait, Representative Lindholm did have a motion. Please.
Thank you, Mr. Chairman. And you know, honestly, my motion is more of a prerogative of the chairman. But my motion, if you want it as a motion, would be that the chairman form a subgroup to work on a bill draft with Ms. Kaiser, Ms. Reyes, and Mr. Mayor, if they'll volunteer their time. Obviously, we can't force them. We haven't passed that law yet, and I'm thinking about that. But specifically to Mr. Revel's point in regards to we can't really fit this into a this round thing or this square peg into a round hole as it stands right now. But instead, we should concentrate on defining what this actually means and what personal data actually looks like. And once we have that definition down, I think a lot of it really takes care of itself. So that would be my motion if you need it.
Well, and appreciate that, Representative Lindholm. So I believe this actually started as a working group. It's under the direction of our good colleague, Representative Yin. And so we already have that working group, but this is perfect because now we have some more players to help expand that. And I can't recall, maybe Representative Yin, you can, do we have other members working on this with you? I feel like we would have assigned members first meeting or so.
Mr. Chairman, I did bring in Mr. Reville, and I had conversations with Chris Land. We only had one meeting, but I think this is great to have some more discussion around the topic.
Perfect. Then, yeah, why don't we, it sounds like Ms. Kaiser and Professor Reyes are both on board. So then, Mr. Mayor as well. So why don't we add them, the three of them, to that sub-working group and continue the work from this point forward. And we'll have, I think we'll have more specific direction as we chug along here, but just know that that's going to be the, and obviously Joel, you're not left off there. You're still on the hook, but we can, hopefully with that group of people, we can start to move the ball and get something generated. Joel.
Yes, thank you, Mr. Chair. I think it would be appropriate if everyone agrees that rather than being data trust as a subcommittee, that we sort of retitle and repurpose it down to defining data as a concept or an asset, whatever folks think. Thank you.
I'm on board with that. Absolutely. And
sounds great, Mr. Chairman, if I may.
Yes.
So I think I just need the contact information of Professor Reyes and Ms. Kaiser from LSO, and I will organize a subcommittee meeting for that.
Clarissa, if you wouldn't mind just passing that information that you've gathered and collected on to Representative Yin, and then everyone can get in contact.
Absolutely, Mr. Chairman.
Cool. We're off and running. See, anyone else out there in the world getting ready to comment publicly at the Wyoming Select Committee on Blockchain, know that what happens is you get enlisted. So it's a prime example. We put you to work. All right. Anything else on this topic? Then what I'd like to do is take a brief break. We'll take a 15-minute break, and then we'll come back. And you might feel like you're behind, but if you look at your agenda, we left a chunk of time at the end of the agenda. So I think we'll probably still end on a good time today, maybe a little bit over. So go ahead and mute yourself, turn off your video, and we'll reconvene in 15 minutes. Usually when my camera comes on, other cameras come on and we're ready to rock and roll, but looks like we're waiting for a few folks.
Usually we're waiting for your camera to come on, Mr.
No,
Chairman.
that's what I'm saying, but I'm ahead of schedule this time.
Weird.
Okay. Well, we're looking at in just a few seconds here as we're getting ready to move forward on the smart contracts. A couple presenters. I'm going to go ahead and Senator Rothfuss, are these?
Yeah, Mr. Chairman,
are they
I'll introduce that if you want once
Okay.
we're ready to roll.
That's what I was going to ask. And are these individuals jointly?
Yes.
So I'm just going to go ahead and we'll get them, everybody in.
Let's bring them all in.
These individuals. Okay.
And everyone, the YouTube is lagged relative to the Zoom, so make sure you're killing your YouTube videos as you join into the Zoom discussion.
Okay, and I think we're probably ready to, we'll get rocking. We have people coming in and out of the meeting based on other commitments and legislative commitments, but we'll just press forward. Senator Rothfuss.
Great. All right. Well, thank you, Mr. Chairman. I had an opportunity to have a conversation with these gentlemen the other day. They had been communicating with Senator Driscoll from our select committee, who I know is now busy over in TRW committee, but he pulled me in because the conversation that he was having, which relates to Lee Stein and Spiral Health and his community, and a lot of us have worked with Lee over the years on Spiral Health and the good work that they've done here in Wyoming through the community health fairs and the Wyoming Health Fair. But there was some discussion about the idea of simple language smart contracts that began to come into that discussion as we're looking at concepts such as maintaining the privacy for healthcare data, healthcare related data, but still using that data in positive and beneficial ways. So how do we get there? That led to a good conversation that I thought was really exceptional background for all of the topics that we've been looking at, whether it's digital identity, whether it's data trust that we were just working with, because it helps to enable a lot of those things and get back to a more, I'll just say, user-friendly way to engage blockchain and advanced digital ledger technologies, which is going to be a little easier to consume. And interestingly, I think it also ties in with what we were talking about with electronic wills, of trying to get to some plain language concepts. So I wanted to make sure we had an opportunity to hear from them as a bit of an education piece so that we can understand kind of what's coming. And then there might be some opportunities to work together on some of the projects that we have, recognizing that Wyoming is a great sandbox to play in and to incubate these ideas, as we've already done with Mr. Stein over the recent years. So with that, we have Mr. Lee Stein here, and I'll ask them each to introduce themselves a little bit, provide a bit of background to the committee before they get into their presentation. Henning Diedrich. Henning is 7 or 8 hours ahead of us right now. So Henning is doing a wonderful job of being here with us when it's about time for him to have been asleep for a couple of hours. And then Marcus as well. And I welcome all three of them and would appreciate a brief introduction from each of you. And then the floor is yours to provide a presentation similar to what we discussed the other day, trying to get into this idea of these plain language contracts. So with that, maybe we can just do a quick run through, starting with Lee and then Henning and then Marcus, and provide a little bit of background so that we've got some context. Thank you.
Yeah, thank you, Senator Rothfuss. Lee, just introduce yourself for the record, please. You're muted, Lee.
Thank you, Mr. Chairman. Hi, my name is Lee Stein. I'm chairman of Spiral Health Wyoming, Inc. We were in the area of digital medtech, and we work closely with affairs, and we work closely with a number of the utilities in the world of as part of the issue of data and forth. And there were some moving around this space recently became best to bring your attention. And so because the meeting over, the last one was a bit longer than expected, I'll just the intros. But I'd like to say that Professor Reyes during that call did mention the concept of Lexon as a way of doing contracts and smart contracts and information, which I thought was a fabulous lead-in. And Henning is the author of that effort from Germany, who is joining us today. One person I'm bringing on, and the other is Marcus Shingles. Marcus and I first knew each other in his role at Deloitte when he was running the innovation program in conjunction with Deloitte and Singularity University and the C-suite executives of most of the Fortune 500 that they were involved with. And he became CEO of the X Prize Foundation, who as all of you know, I believe, I am a trustee at. And it was during tenure that we launched the Integrative Test Center with Basin Electric up in Gillette. So with that, I'd like to turn it over to Marcus because he is a specialist, a world-class specialist in digital disruption and digital conversion and digital innovation. And he works closely with Henning as part of our efforts to do digital health the right way. Marcus, could I hand it over to you, please?
Yeah, thank you, Lee and Marcus, before you jump in there, Lee, and I was hoping it would get better, but maybe it was just me, but you were cutting in and out a lot. And so maybe while we turn over to Marcus, see if, I don't know if that's your Wi-Fi or see if you can't maybe try to figure that out. If not, we'll deal with it, obviously, but just giving you a heads up. Marcus, please introduce yourself.
Thank you, Lee. Yeah, Lee, you were just a little choppy. I mean, I think everyone heard everything, but it was a little choppy, so you might want to check the mic or something. But I think did everyone hear? I mean, I was able to comprehend everything Lee was saying. Great. Hi, everybody. It's a pleasure to connect with all of you. I'm going to introduce Henning more formally in a little bit because I really want him to do most of the discussion here because I think he's a real asset that you all be able to leverage. Carla, who you just enjoyed, who's a real expert in her space, actually Henning referred her to this program because Henning's been working with her quite extensively the last few years. I can just tell you from my perspective, as someone who knows a lot of the top engineers probably in the world around this capability, I haven't met anyone quite as unique as Henning. And you're going to see with the street cred he is really the authoritative source that advises governments and businesses. So I'm not going to steal any of his thunder, but I think part of the real value of this discussion is I probably offer the least value, and it's mostly Lee with his with everything that Lee normally does, and then Henning in this topic. What I can share with you is I'm going to put some context around this dialogue. I listened to a lot of today. I know Henning listened to a lot of yesterday as well. I'm actually in Wyoming as we speak with my daughter who lives in Jackson Hole. I'm down at the Alpine Refuge, and I'm relocating here. So I've got lots of family and friends. Talk about street cred. My brother-in-law was the Santa Claus in Jackson Hole over Christmas. So I think if anything is credentializes me to this group, that's it. That I know Santa Claus, the actual Santa Claus in the Jackson Hole Square, right? So his name is David. I know who you are. Okay. So let's do this. I want to set a little context. I'm going to share a screen. Let me put this in screen show mode. I'm assuming everyone can see it. Okay. So the purpose and objectives, and I think this group is obviously a more advanced thinking group. So I'm going to go through this pretty rapid fire, I think for everyone's sake. But I think there's a few key things as I listened to the last, bits and pieces of the last couple of days. One is there's been a lot of focus on the ideas for how Wyoming is going to be using blockchain architectures. I'd like to share with you just some lessons learned after doing digital transformation for nearly 30 years. There's some very well documented reasons why these projects have a high failure rate. When I say high, it's about 72%, according to Harvard Business Review and others. So I think it's good to maybe just expose you all, if you're not already aware, to some of the Achilles heels or blind spots that potentially can creep up on you. I think that's a healthy dialogue if the committee is not currently having these discussions. But that does set the context to one of the areas, even from the last discussion, which is probably the Achilles heel for any model related to using a decentralized architecture for data, which is the trust of consumers and privacy related. And as you guys just went through for 2 hours, that's not an easy code to crack, right? You will learn on this call through the work that Henning's done. That's where he's been focused the last 3 years of his life, and he's done something extraordinary, and I'll be able to introduce that. By the way, I'm not an investor. What Henning has developed is actually a nonprofit open source, so it's not, there's no commercial incentive behind what we're talking about today. So if you see our excitement level getting up, it's not because we think we're about to make a sale, it's because this is our research and for Henning, it's his life's work. And that's the tone that you should perceive here. So, there's some lessons learned, the Achilles heel piece, and then, I'm sure you guys, it's come from the discussion, Chairman, that we had a few days ago with you and the other senator, which is, ideas are easy, but execution and adoption is the hard part. So how can you mitigate risk specifically around that whole data and trust thing? So I think we're going to scratch the surface pretty deep with you guys today, not on a theoretical point of view, but on some real areas of solutions that are evolving in the architecture of these capabilities. We already did intros. Henning and I have known each other for years. He was an executive at Boston Consulting Group's Digital Ventures, really head of their blockchain efforts. Before that, he was at IBM leading some of their major blockchain efforts. And then of course, Lee is one of my favorite, like many of you, he's one of my favorite people in the world. So I appreciate Lee, you making the introduction and all the incredible work he's doing at Spiral Health that he's brought me into, because that's some exciting vision there. By way of background, Lee mentioned I was a CEO of XPRIZE. Before that, I was a partner at Deloitte, which he mentioned. I was one of the key leads in the innovation practice, working with Singularity University. I worked a lot with governors, the governor of Pennsylvania, a lot of prime ministers. Well, not a lot, but I've worked with prime ministers on this topic and related topics of innovation and digital technologies, as well as major corporates. Before that, I was at Ernst & Young for a while. I had my own business for a while. I started at Kellogg's. Currently, I'm at Bain & Company, a Bain advisor in their innovation practice. And then more proudly, I'm involved and on the board of several nonprofits that focus on education to underserved communities. So if, Mr. Chairman, if you end up having a committee that focuses on using virtual reality and augmented reality to teach students in underserved communities, to reschool them, to make an income, that'd be a topic I'd be highly interested in, because it's close to my heart and I'm doing a lot of work in that space, okay? Real quickly, there's ideas and opportunities that pop up related to these new emerging technologies, blockchain being one. Others include artificial intelligence and 3D printing and biotech and robotics and nanotech and virtual reality, et cetera. And what I've seen most organizations do is they have these initial kind of awareness and education to get some exposure. Wyoming clearly has gone beyond just scratching the surface into sinking their teeth pretty deeply into blockchain and what that means for the citizens of the state, as well as what the government can leverage as a capability. The hard part is going to be the execution and the scale of any solution. And there's quite a big gap here to how companies think about doing this bridge from a design and awareness perspective to actually executing and scaling. And what I'd like to just put on the radar for the committee, if it's not already on your radar, is the tough part is probably not going to be the technical capability in the end. I think that will even be, I think the tough part is going to be the behavioral science piece and the ability for citizens, as well as just the local jurisdictions, the government, everybody involved, all stakeholders, to actually adopt and engage with a completely new way of thinking and process, right? It's just not it's not an easy thing to do. The part of the answer lies in extending an ecosystem, which clearly you guys are doing by having guests like Professor Reyes, Henning, myself, Lee, and others, you are extending your ecosystem. So you're following that strategy. Another thing that I'll just briefly touch on, which I think is really an example of what, kind of a casebook example of what Wyoming's doing. It's really an edge strategy versus the core. And we'll talk briefly about that before we get into the specifics with Henning. I want to share with you, a little bit of the reality check on what probably Wyoming and your committee is up against in terms of deploying these solutions over the next few years, in terms of the vision that's being created. This depicts the last 10 years of what is really considered Industry 4.0 and doing digital transformation. It was really around 2010 that you started to hear about Industry 4.0 from the World Economic Forum and just all these new things. 2010 was about the time you started hearing about blockchain and self-driving cars, et cetera. And if you look at and kind of dissect how organizations, commercial organizations, nonprofits, and government have performed over the last 10 years, there's a lot of telling evidence that certain things were done very well, but there were certain things that were done very ineffectively. And specifically, it started off with the first 5 years where it was a little bit of shiny objects and fear mongering, right? If you think about it, it was, a little bit of a hype cycle around many of these topics. But maybe that was good because it really called to action government and businesses to maybe pay attention to things that they were hearing about that they normally weren't paying attention to, like blockchain or self-driving cars or 3D printing, right? It was about 2015 to 2019 that as organizations and governments tried to deploy some of these technologies, they realized this is a lot harder than just the technology. This requires new process models. It requires new metrics. It requires new ways of thinking. It's really developing new muscle. And even after that 10-year period, this was the headlines. And I think this is what I want to get on your radar. 70% of these types of programs, these initiatives, have a failure rate. And this is very well documented. So this is what I've been living and breathing over the last 10 to 20 years, is the ones that are successful versus the ones that aren't successful and why. And you see that everybody points to the exact same thing. Culture and behavior is the issue and the challenge, right? So no matter what you're looking at, and I'm just driving on the point that the industry really, this is really a blueprint of what government and what commercial businesses did over the last 10 years. And those that got it right, who were successful, that 30% or that 28% that have been successful, we're focusing on this last element of organizational change and transformation, looking at this through a behavioral science lens as much as a technology systems implementation. And sometimes that gets put on the back burner because there's so much excitement around a new technology, a new shiny object, that you forget this a little bit. So why is that important? Because the behavioral science, the cultural change here is going to be really dependent on the citizens. Them feeling comfortable with how you use their data, whether it's for spiral health and the health data, whether it's using blockchain for voting or for trust or for wills and whatever it might be. The behavior change that could potentially be the Achilles heel on this is, will consumers ultimately trust, will citizens ultimately trust this model, regardless of what people say, even if perception is different than reality? And I wanted to spend a minute talking about that because I do think that's the blind spot, or in your guys' case, it's not your blind spot because you just spent 2 years talking about an element of this. The World Economic Forum has basically just come out and said, if you look at Industry 4.0 post-COVID, this is even on steroids, right? The need for more collaboration and looking at effective change management. So, this whole discussion is about how do you take that behavioral science piece, and I want to get specifically to this because what I'm putting my finger on is if the state of Wyoming or any other jurisdiction starts to look at blockchains being used and tells the patients or consumers or citizens that this data will be used for a common good and it's safe and protected, there's still going to be that distrust, right, that we've all been talking about. That's context for what Henning has been spending 2 or 3 years of his life on, trying to think about how to crack that code. And that's the strategic context, what he's going to talk about. Before we do that, I want to give you guys props because I think whether you know it or not, you're doing a casebook example. I think for the United States, on what an edge versus core strategy looks like. So this is real innovation science. I know that might sound like a hokey consulting term, but I definitely think there's a practitioner. You can practice innovation as a science, just like you have marketing research and marketing analytics and marketing science versus just marketing. And one of the things I've learned from one of my previous colleagues, John Hagel, to give him credit for this thinking, is you have your core business, which is, you know, the core United States, like in Spiral Health's case, the core health system of the US. And what's been identified is that the best way to do innovation is keep away from the antibodies in the core, whether it's a business or a government, and try to do things on the edge, which means there's a slightly different type of skill set, a slightly different type of rules, of metrics, away from the core, rather than having the core manage it. Because there are antibodies that resist innovation. It's just a natural byproduct of doing innovation. And over time, the edge will start to scale the core and get more successful. So I really consider Wyoming doing an edge play. Like, even if you look at the role with Spiral Health, you're the edge for the United States on thinking and reinventing how healthcare can be done, which is great because it's outside of maybe the bureaucracy of the core. You do it out in the edge. And the key is, most companies, when the edge starts to have success, it's pulled back into the core. And the strategy to follow is, don't get tempted by coming back in the core. The edge should pull the core out to the edge, and eventually the edge will be your new core. And I think that's the potential for Wyoming with everything you're doing around blockchain, is a real case study to that. So whether you're cognizant and self-aware that this is what you're doing, it's a very good strategy and it's very effective. And I would just emphasize to continue to resist the temptation to bring it back into the core and always keep it in some edge play that lets you fail and learn, lets you have different metrics to be successful, etc. So the question is, it's linear versus exponential thinking. And again, usually in your core, you don't have a ability to fail and learn. Those are bad words. But on the edge, you have different permission because you are innovating at a rapid pace. The thing that we were just discussing, okay, this is the real Achilles heel to, I think, a lot of the discussions around blockchain. I mean, these are all the recent articles, right? It's what we were just talking about. People have a genuine, whether it's warranted or not, have a mistrust or distrust of how data is used, of Silicon Valley, of government, of medical technology, new medical technologies, and now related to governments. This is this month's MIT Technology Review cover story about government using data of their citizens. So no matter how good of an idea that is formulated around data and blockchain for whatever use case, health data, you know, if you get into voting in elections, if you get into wills, if you get into you know, any of the use cases we've been talking about the last couple of days, you're going to have this mistrust piece. So I want you to consider this scenario. You know, let's take healthcare. You know, we'd like your personal data. This is the state saying there's a common good to focus on how do you create a better healthcare system for the state. And maybe data as a common good, as a trust, is going to be valuable for the state. So the first thing is, you know, we'd like your data, saying that to a patient. And, you know, part of the discussion will go, don't worry, it's on a blockchain. And that's going to be not really well understood, right? The average citizen is not going to know if that's what that even means. So what they're going to refer to is groups like, and I actually put her picture in here because Brittany just spoke and she brought this up. I mean, she basically represents third-party advocacy groups that go and audit things that the government are doing to see if they're protecting your data. So the way the storyline is going to go is, you know, the state of Wyoming will come out with some capability, blockchain for healthcare, for example. There's an ask to put your personal data in. There's a comment about don't be concerned because we don't own your data. It's on a blockchain. It's a decentralized architecture. I know you don't know exactly what that means per se, most of you, but you know, this watchdog group will actually validate this and tell you that it is a legitimate decentralized model that has less control by a government than we would be comfortable with. The only issue is the only way that a patient or the advocate group is going to put a stamp of approval on this is after they read the code. Because a patient advocate group is not going to say, yeah, just because the governor told us this is what it does, or the committee told us what it does, or because it says it on their website. No, a patient advocate group is going to do their due diligence and actually read the blockchain code or whatever code it is to say yes. And if you put your data in the system, this is what the smart contracts will do, and this is what's going to happen to your data. And now we validate it. And by the way, if you get into trouble and you have to take it to court, no problem, because we can give it to a judge and the judge can get a developer to come in and translate the blockchain code. You see where the problem is? The problem is that's not feasible. It's not feasible to try to recode. The other problem you have is even if you have someone interpret the code, how do you know that person really understood the nuances of code to be that level of expert, whoever wrote it? Maybe they couldn't interpret all the nuances. Number two, what if the person who's giving you feedback can be bribed or incentivized to misrepresent what the code represents? So I see this, and I've had this in firsthand experience in talking with health companies and pharmaceutical companies about these types of models of putting data like this in a public good blockchain. At the end of the day, until we really figure out how to read blockchain code, it's going to be a very difficult thing to manage, and a very difficult thing for the legal system to deal with. So this is where Henning comes in, because Henning had the foresight to actually think this through years ago, and realize that this is going to be Achilles' heel. This is going to be a real stumbling block. And keep this in mind, whether it's perception or reality, if a citizen of the state starts to hear some of the rumor mill that there's something wrong with the way this data is being used and no one can really validate it, or they can't go read it themselves, what it's going to do, perception or reality, you could really spoil the whole equation. And people are like, stay away from that health system that they're asking to take our data because we don't know what happens to it. Well, what do you mean what happens to it? They've told us it's not going to be used. We have control over who uses our data and how we even get monetized for when people use my data. What's wrong with that? Well, we don't know if it really does that. You can't trust that person. That's the government, or that's big tech behind that. So this is a real problem. And I'm very impressed with Henning's brilliance in thinking this through, because he comes from, and this is a little bit of introduction to him, he created a new language. So this is a person, I don't think most people can create new programming languages, first of all. So that gives you an idea of the caliber of his computer engineering skills, okay? He created a new language where it reads in your native language. It reads in English, the code. So it doesn't interpret into blockchain code. You write a legal contract in English. That's why he knows Professor Reyes. He worked with her when she was at Michigan State Law. He approached her to say, if we take this code in blockchain and we make it read like a legal document that a judge can interpret, that anyone can go read, that a patient's advocate group can go validate, we can really conquer this hurdle of people not feeling comfortable with what's in this black box called a blockchain, because anyone can read it, and more importantly, judges can interpret it immediately. And lawyers can now write blockchain code because it becomes legal documents, right? So it's a very interesting concept. Again, Henning, this is kind of his rap sheet. He just spent 2020 doing a major report for the Singapore Sovereign Wealth Fund. You see that includes advising the Monetary Authority of Singapore and the Singapore Stock Exchange, where they hired him out of everyone to select in the world to do this. They hired him to go do research to say, you're one of the leading thought leaders on this topic. Can you please advise us on how to future-proof this? Not where blockchain is today, because 6 months from now will look completely different. It's just such an evolving architecture. And Henning is one of the few people I know that is kind of looking future back at where this thing is headed. So rather than going from A to B to C to E to F, Henning has kind of got the lens to go right from A to F. And I'm putting my reputation online to say that and I don't do this, I don't give people accolades like this very often, because I think it's only if it's well deserved. He truly is someone that is thinking through creatively and architecturally where this is going, and is thinking of a lot of the solutions to get there. So he's a resource for all of you on this discussion. This is his background. As you can see, he's done a lot with the European Commission, University College of London. He was the lead guy at IBM. He was the lead guy at Boston Consulting Group's Digital Ventures. He made some of the first blockchain actual systems that have been put out there in real use. It's hard to find an individual that's gone through a full life cycle like that. So please use him as your resource. With that said, I'm going to turn it over to him. And the only thing I would add is kind of a segue is, remember, blockchain's a proven exchange of value, right? So you could use the chain itself to incentivize those behaviors we talked about. So once you give consumers trust because they can read the code, or others can read the code on their behalf, so there's full transparency on what the smart contracts will do, you then have the ability also to incentivize behaviors through tokens that maybe can be turned in by the government for tax credits or some other mechanism that citizens get for basically complying. So if I'm a citizen and I let you use my data and I have the lockbox to that data, and you can incentivize because you give me token, maybe I use on some utility bill or tax credit, et cetera. Not to mention the fact that if I do my performance, like I exercise as I'm supposed to, that Spiral Health has recommended, I get rewarded when my Fitbit says that I exercised. So remember, whenever you have a blockchain architecture, of course, you also have a means of transferring value. And I think that's another interesting concept that that I've learned a lot about from Henning, because I consider him one of the experts in the space. So without further commentary, and let me pause there before Henning jumps in, just to see if there's any questions or comments, any feedback on what I just shared, and then we'll turn it over to Henning. And Henning, I'll let you track the screen right now too.
Thank you, Marcus. Any questions for Marcus before we move over to Henning? No? Henning, I'm going to say that I think you just received the longest and most thorough introduction in the history of this committee. So I'm looking forward to this presentation. And I am familiar with some of your work, obviously. And so I'm just looking forward to it as well. But we'll turn over please introduce yourself for the record, and then the floor is yours.
Yeah, thank you, Mr. Chairman. Thank you, Marcus.
You can take control of the screen, Henning. You're going to present on your end, so go ahead and.
Yes. Just for the record, I'm Henning Dietrich. I'm a programmer. I'm the founder of Lexon Foundation. And that is basically a company that is driving the development of a human readable language for programs and for smart contracts. I, before that, worked for the Boston Consulting Group as a director for blockchain, and for IBM. I was the first architect of the Hyperledger Fabric blockchain of IBM's. And before that, I've been working in databases and in language design, in crypto, all the stuff that's coming in handy at this point in the crypto space. And I would like to give a presentation now on human readable smart contracts, and also what they can be used for data privacy. And Mr. Chairman, I would like to encourage that if there are any questions on the way, and I might not be seeing that somebody is showing a hand, please interrupt me. I'm happy to make sure that the pace is appropriate for everybody to be able to get the most out of it.
Yep, I got your back, Henning. I will stop you if anyone has any questions. And committee, same, please don't hesitate to. You don't have to wait until the end. If he's giving you the go, please jump in when you feel the need.
Okay, thank you, Mr. Chairman. So I will share my screen here. What I would like to talk about is about a natural language programming paradigm that in the end has the somewhat stunning propensity to allow to have law on the books that's written in plain English, but that can also be executed as a computer program. And actually to drive it to that extreme is something that Carla invented. I was very focused on blockchain initially with this whole project, and then later extended it towards general programming, because it turned out that looking beyond the blockchain bubble, what we were doing here did not actually exist anywhere in computer sciences. But I would also like to make very clear that I'd be very excited to work with you guys, to putting this to actual reality, to work with you to get ahead of Delaware and do something that those guys haven't done yet. I've been following the last 2 days, and I tried to weave in some of the information about what is interesting to you at this point into this presentation, to also create touch points where a future development might make sense. And I think throughout, it's possible that this all takes it one step further than until now the discussion could ever go. And it might take a moment to just sit back and digest after we looked at this, and then maybe after some days or weeks come back to discuss what might be possible now that programs are human readable and that law could actually program, and vice versa. And I'll be very happy to answer your calls or emails at any point in time, and find a flexible way to try to find out what's worth pushing forward together. So Lexon does something that has been looked for a couple of decades, and that is the analysis part of computational law. The revolution that Lexon might bring, and I think will bring, is comparable to what happened when discovery started to be electronic, starting in the 70s. And now, obviously, it is normal for a big case to go through years of emails and electronic traces of communication. And obviously, that didn't exist, the thousands of years of the history of law before that. So that really changed the picture. And what Lexon is doing is bringing the second part that had also been predicted since the 40s, which is basically analysis. Because until now, it has been proven to be a relatively tough nut to crack to try to understand or make a program understand what a contract really means, to really parse natural language. And to a certain extent, Lexon is the prediction that it will take a little bit until computers can really do this. And this language that we're proposing here is an invitation to meet in the middle, so to say, to create a middle ground where machine and computer can agree on the same language, and because of this, both fully process it. So what I'm going to show you is plain English that reads a little bit peculiar. You can see that it is that there is something behind why it is, how it is. You can also see that in this, it is by nature somewhat close to how legal English works, that uses some particular phrases that mean a certain thing and that are used because they are unambiguously pointing into a certain direction, or very ambiguously pointing to a certain direction. What Lexon does by bringing those two sides together is really like collapsing the worlds of programming and law into one. And this takes out a lot of intermediaries. If you all of a sudden have two somehow relatively distant elements like law and IT joined into one document, there are a lot of intermediaries, a lot of industries even, that are all of a sudden not needed anymore. It takes out incredibly much delay and also a lot of cost. And the result of it has some rather emergent effects. What it all is started to surface only bit by bit, but it's also not surprising because what those two seemingly very distant sciences have in common is actually more than some people know. And I only discovered this while being on this journey, that actually programming was invented by a law professor. And that's not just a peculiar German view or anything. It is really the case that this German law professor, who was a contemporary of Newton, invented programming and created a thesis that is regarded as the first document of computer sciences. And in this thesis, he proposed to make a program out of a particular piece of law that itself was at that point 1,300 years old, because it was clear to him that it was very, very procedural. And there should be some way to automate reasoning about it the way that it's needed. And this is this very first program, so to say, that was proposed, and it's a piece of law. And it's a particular key piece of law. It's about who's a contract even for, whose interest is a contract even in. And that is considered the starting point of programming. And I'm showing this here at length to encourage you to follow me into this a little bit unexpected direction, that law and programming actually are much closer relatives than is normally understood. Now, this is Lexon. What you see here, white on black, is an escrow contract for the blockchain written in Lexon. This is the program itself. It can be run like it is on the Ethereum blockchain, for example. Many presentations that are designed a little different. I'm focusing around showing actually how I'm live programming this and then sending to the blockchain making a transaction into the escrow, and then later making a transaction back out of the escrow. And that is something that is, in a certain sense, on the technical side, there is no magic involved. We're using tools that are in part around for decades for compiler building. We're using very normal techniques. The real techniques, though, it's not just a superficial way of just reordering words, or it's not just text replacement, so to say. It's a real, it's really compiler technology. It's really real language design behind it. And meanwhile, there's also a lot of work involved. I mean, I have been pushing this for 4 years now. And by the way, initially with a lot of help from Carla Reyes, actually, and also Oliver Goodenough, who both helped me writing the first white paper about this in 2017. What you see here on the left-hand side is the realization of one goal I had going in, that was to make a smart contract presentable to a judge. And a key moment for me was sitting in a panel by Koala, where judges were basically laughing about the idea that they would ever look at a smart contract. And they said, yeah, well, I will never, ever look at the program code. I will pull every procedural trick that I can to avoid this. And then if I can't avoid it anymore, I'll pull in the experts. But I will not look at the program code itself. And what this affects, even though I know that Wyoming was pioneering here and years back already made clear that smart contracts can in fact be contracts in front of the law. The problem, maybe even in Wyoming, but at least in most jurisdictions of the world, is that the magic of blockchain, the magic of smart contracts, that they can move money. That programs, that bits and bytes and text that we write on our computer screens all of a sudden can move money directly, is only moving possession. But for a company to use this, and I was working at IBM back then, to create a real business case out of this, you would still have to make sure that you cannot, if you build this into millions of IoT devices, for example, be sued by a class action, and all those shifts of possessions are great, but they have to be rolled back because you haven't shifted ownership, or something was going wrong on the level of a smart contract, or it is only claimed frivolously that this was the case. And this is where the original idea came from, that would be great to have a smart contract that is actually readable by a judge. And this is the point where we reach now. We're still improving it. We're still making it better. We're saying we're at version 0.3 now. And it has actually gotten better than I thought going in was possible. One of the open source legends, Brian Fox, actually pushed me to go all the way to try to achieve something that I wouldn't even have tried, which is like, you can now read this without learning anything up front, right? It's not only you don't have to have any idea about programming, you don't have to have any prerequisite. And one of my favorite slip-ups, so to say, when I was presenting this live, as I mentioned, was actually to the head of BCGDV, was that I typed wrong, agent is a person. You see on the left-hand side, like with this fourth line there, and I typed, oh no, I typed wrong, fee is an amount. I didn't type an amount, but I typed fee is a person. And I was just distracted talking to him. And he interrupted me and it was like, oh, that's probably a mistake, right? And that's astounding in itself, right? Because this guy saw this language for the first time, and after a minute, he was able to catch a bug. And then he proposed, you probably wanted to write amount. And that's even more fascinating because he was even able to guess what this language is, because yeah, of course, in English, what makes sense here as a class of words is fee is an amount. And this is absolutely not the case for a normal program language, because in a normal program language, this would be something like uint 2556, or it's just int, or it's just uint, or whatever. It can be any kind of things, but nobody who has no training in that particular language would even dare a guess. And that is how different than, what kind of a different creature than the programming languages that came before this really is. And the mere fact that sometimes can seem small, that anybody can read this, has very surprising consequences.
Hey, Henning.
So
Henning, I just want to point out something to the chairman and the rest of the committee. I know that a lot of what, I think one of the beautiful things that Wyoming is thinking about with blockchain, similar to when I was the CEO of X Prize and we partnered with you guys on vertical takeoff and landing, was like how do we, or the Carbon X Prize, it was about how to get jobs and economy and competency built in the state of Wyoming that offers new jobs on the bleeding edge. Keep in mind what Henning is showing you here is that citizens of a state, rather than learning coding, which maybe is a skill that's not going to be as relevant in a few years, you could build an economy off of a bunch of citizens that actually become legal analysts that know how to write smart contracts. You know what I mean? Like, so the world's going to need these people that know how to write things this way. And I don't think it's monopolized just by people in legal school. I think you can teach this like you teach coding, which makes it a very applicable skill. And there's going to be a workforce centered around this. So I think there's an interesting thing happening here when you take out the complexity of coding to make it a language. You now have a lot more people that can get in this space and be trained. And I think the leapfrog opportunity for Wyoming is the first mover advantage, I should say, is a leapfrog opportunity because it's helping you fulfill some of the vision and get rid of some of the blind spots that might inflict issues around how you do blockchain and the adoption by your citizens, that whole trust thing we were talking about. But also there's a new economy of workforce there, right? So, sorry, Henning, I just wanted to share that with the chairman and the committee.
I guess you have to apologize to the chairman.
I apologize, Mr. Chairman.
You're fine, Marcus. Although I don't know if you're aware of this, but there are 2 Marcus shingles in the meeting, which is tripping me out. But I think one is a black screen Marcus shingles, and one is the Marcus shingles.
I've learned that whenever I'm on Wi-Fi, especially in Wyoming, I should probably be on 2 computers so I can see what I'm presenting and the way that other people are seeing what I'm presenting. So you see me logged in twice. That's all.
Thank you, Henning. Please proceed.
Thank you, Mr. Chairman. So I would like to, but also thank you, Marcus, for pointing this out. This is really also a shift we're creating a new profession here. I'm convinced of that. Some lawyers don't like that idea. Some programmers don't like that idea. And then the question is, who is going to be what we call legal programmers, like legal engineers, right? And they might need a little bit of both. They might need legal training and they might need programming training. And it might turn out that actually you better just take programmers and train them in legal stuff, or vice versa. But it does look to me like this is going to be a new profession. And some responses I'm getting from experienced lawyers are confirming this. So I would like to continue looking at a couple of general aspects that are arising from this. And then I would look at specifically, how is this used on blockchain? And how can this be used making laws? Then also I would like to comment on the filing questions that we had throughout the day, and also on data privacy, and kind of wrapping up or complementing rather the discussions that we had today from technical side. And as I will refer to again later, generally what I'm adding here is what is technically possible right now that might not even be well known at this point. And it is very much in the same trajectory of the difference between possession and ownership, where we're bringing, on the one hand side, a lot of thought into what has to happen on the side of the law. But this is also here now going to be what is going to be possible technically and what is new that is possible technically that should at least not be frustrated by the law, but ideally supported. So, and then in the end, I would like to talk about specifically what Wyoming might do to use the occasion, but also to support this, and what we would love to do for Wyoming. So one of the things that Lexon allows is it can stress test law and contracts. If you think about it, there couldn't be a bigger difference between a contract or a computer program. A contract is ideally just written and then it's put into a drawer and then hopefully never taken out of it because everything goes according to plan. If it doesn't, somebody takes it out, tries to understand what it means, brings it to a judge who also tries to understand what it means. A computer program works completely the opposite. If you run a computer game on your computer that heats up your vents, this is because it is actually doing billions of operations a second that are all pre-scripted. They are all result of what has been written by a programmer. And it's a lot of different layers of programs that are all stacking up. But every single pixel that moves over the screen is the result of a calculation of a formula that is the program. And so you couldn't really have a vaster difference between how a contract is read, how often a contract is read and then performed about, and how often the program is read. That means that in the culture of programming, we have developed different tools for testing, and some of them are just called brute force tests. And that just means you throw a lot of random numbers or good guesses where something could fail at a program. And we can now bring this to contracts with, of course, the result that we will find loopholes and fringe cases that might have been honest errors and just have been overlooked. And the same is true for law, that we can just use it. And because the computer can now understand it, we will be able to feed it millions of test runs that will then find holes that might be in the logical structure of the law or of the contract. Another thing is that Lexon brings transparency to something that is happening already. We have, at least in the United States, we have black box algorithms that are mandating minimum sentences to judges where nobody knows what's inside, actually. Where, in a sense, nobody actually knows. No human being has actually signed off in the concrete instance that somebody goes to jail or is punished in a certain way. Lexon can give the power back to lawmakers, and with this, the public, to actually prescribe concrete pieces of law that can govern these black box elements. Or Lexon can be used to mandate that these kind of algorithmic boxes can be made transparent because they are to be programmed in Lexon and then audited by committees that are created for this. It all results into a situation where the excuse that exists today that something has to be programmed and then it cannot be checked anymore because we have to trust the programmers that they did the right thing, that this is going to be a much weaker argument going forward, but instead, the more that Lexon will become a tool that is used across the board, it will be possible to mandate to program stuff that must be readable and should be readable, should have been readable all the time, make it readable to lawmakers and the public again. Another thing is that today we have a lot of algorithms that are, let's say, having a pretty strong effect on people's lives. To stand out, one of them is the intelligence in self-driving cars that already at this point has to be programmed in a way that they are making life and death decisions. This illustration above is a simple case, is the decision of the self-driving car to make a full brake and then by this risking the life of the motorcycle driver behind it, to make good on just maybe not scratching the car in front of it, or is it going to ram the car in front of it, saving the life of the motorcycle driver behind it? And this goes beyond putting the car into a minimal risk condition. What is actually interesting is that the half page of definition that the minimal risk condition is at this point in the draft that you had before you, I think yesterday, is only very circumstantially describing how you should transfer the car into a certain condition. But Lexon can be used to describe how it should be put there. And that is something I'd love to work with you on, to try to find out how this could actually pragmatically be done so that it is starting to be the seed, so to say, of a blueprint of something that can become much bigger, where regulation itself and the law itself starts to be a program that actually runs in the self-driving cars. And then there is no wiggle room for honest mistakes or a little bit disruptive innovation that cuts the corners. It is just very clear what a car then has to execute as code that makes these crucial decisions. Another aspect is that obviously cars can be shut down now and remote control. And maybe we would like it to be in a very precise situation only that this can happen, and that lawmakers describe these situations that can happen, and that this is then built into a car. And then no police overreach or somebody being too overeager can then just stop basically your vehicle just maybe for a mistake or because a pattern applied that made it seem a good choice.
Henning, at this point, I'm surprised that Representative Lindholm isn't extremely triggered by the concept of the police being able to shut down your vehicle. Representative Lindholm.
Yeah, I don't drive a self-driving car. So, and it'll be a really cold day in the South before I ever do.
Henning, go ahead, sorry.
Yeah, thank you, Mr. Chairman. I mean, obviously then I wasn't clear enough. My point is that Lexon can be used to rein in the discretion of the police. Because however it works now that the manufacturer or the police can stop your car remotely. And the clearer lawmakers can define under what circumstances this should be possible, and then embed it into the car, like the law itself runs in the car as a program, that's again, all the middlemen that are being cut out, make the blurriness of when the situation is reached or not go away, so that by crafting good law, you can protect people from being remote controlled, basically. So in this sense, my understanding of Senator Lindholm is probably that he should like it, what Lexon can do there. Now, this is the funniest slide, but this is just as important. Social media today is creating bubbles, and of course, we all know it's advertisement that is basically driving the algorithms in a way that is optimizing income for social media companies, but at the same time, creating a lot of a very fertile ground for fake news and very harmful information weapons, you could say. And again, I mean, regulation and laws that would protect citizens from these kind of bubbles to be created around them might be articulated in Lexon, and how much freedom you want to give social media companies, or how much protection you want to give people, or however you want to phrase it. The important part is that Lexon allows you to step in and basically say, these are the rules, and you please build them directly into your server, because you can run them there. And this is a perspective that until now just didn't exist. You would have a very hard time to make programmers, if they don't want to, do exactly what you prescribe them to do, because the distance between the law and the regulators and the programs and the code that runs in the end is just so many people. It's such a game of telephone, and then nobody could and can in the end get a hold of who did what line of code wrong that resulted in a certain situation if it's just skillfully covered up. So this is what Lexon can end. And I think the funny cartoon that is at the bottom of this slide is actually something that's very close to my heart. It is possible that Lexon is our best chance to actually regulate autonomous robots that are war machines. We will have to, at some point, come to regulation also about this, because this has already started. And to my big surprise, I saw somebody bringing this up, being laughed at a panel, because it sounds so like science fiction and Star Wars, but it is something we have to talk about. And Lexon might be a good way to have lawmakers be able to write the rules that might actually look a lot like the robotic laws that Asimov dreamed up decades ago, and have them embedded without any wiggle room into the code of robots. And I can't help it. It sounds like science fiction, but we have to look at this. And I think these are probably maybe at the federal level in the end, but about the use cases of Lexon, this is something that I think might become very important. So now I would like to look at the rather special use case, which is the home game though for Lexon. How does it work for blockchains? Now, I mean, just fundamentally, the big question is, why doesn't it exist yet, right? Because nobody gets the idea to do their bookkeeping on just trying to read binary numbers, right? We have shiny interfaces for that. We have graphical interfaces. We have easy to use programs. So why would smart contracts, if they deserve the word to be contracts, or if they are agreements between people, why are we content that they until now looked like this? Which is, granted, actually for programmers, it's a super accessible language. It's an easy language, but it's not something a judge will ever look at, and most people will probably never be able to read this. Now, Lexon is the solution to this, as it reads like this. And if you can create an Ethereum program, a smart contract using this language, there is very little reason left why you would use this other language. Until now, obviously, as I described, you have all these stations that you go through. You have the game of telephone to create a smart contract, starting with an idea for a business case and then going through the legal department. And even that is really tough for those two sides to speak with each other, where business people like to think of creating opportunity and legal people more like it's all a zero-sum game. You win, I lose. And then the programmers have yet a different mindset, and hopefully they are going to be able to program what came out from these first two stations. Lexon enables this to become a real communication. Programs that are programmed in Lexon can be verified both by legal people, which might even be the more important aspect, but also by business people, which is also very important, so that they can see whether the outcome is actually really what their intention was. But it goes beyond this, as we just talked about. It can also be read by judges if it's necessary, or by arbitrators. And it can also create a do-it-yourself economy, and becomes much more accessible for small and medium-sized businesses. In the end, it's also about the consumers. It's about the customers. Even they can now read what they're asked to enter into, if we're talking about smart contracts here, which in the past was just not possible. And we have a lot of very interesting initiatives in the blockchain space, where a lot of people that are really interested in a revolution in how organizations can work together and how a community can be organized are coming together. But until now, they all had to be content with the fact that only the programmers amongst them were actually able to read the smart contracts. So Lexon fills a gap that had existed before, where you on the one hand had the legal prose or the agreement or the idea of it, and then you had the program code. And MIT and others have actually predicted that we need something in between, which they call the smart contract definition language, that is between the program code and the legal prose itself. And that's pretty much what Lexon actually is. And it was predicted basically a year before I started working on this. So in this sense, Lexon allows both sides to read it, to view it, and brings them together. That's also what the actual program that can translate these Lexon codes is doing. And another sense that it is compiling, for example, to Solidity, which is the language that Ethereum then needs to actually run, but also compiles out of the natural English that it's written in, a even more readable natural English version that also comes with a glossary, which tries to take out the last bit of awkwardness that might lead to misunderstandings from the original text, so to say, that you have to write it in. In a certain sense, there was in the blockchain world, some of you might know this, a very strong movement towards formal verification, which is a mathematical way to make sure that programs are correct. That was a reaction to losses of hundreds of millions of dollars because of programs that went wrong, that had bugs, that were programmed in Solidity. What Lexon allows you to do is something else. Lexon allows you to see much clearer what the actual business logic, so to say, the actual intent is that a smart contract is facilitating. And this is arguably much more important even than formal verification. It is also very easy to extend Lexon programs. If, for example, if you have this example here and you want to make a change because you're let's call it do it yourself, and take a blueprint from a repository that's public, and you get from that repository the black letters, right? And in this case, it means, okay, there is an entity that's called Oracle, and that is going to be deciding what if the payout can happen or not. So then you can add this very simply to a blueprint that you had looked at before, where maybe only the sender was allowed to facilitate the payout, which means in this case, okay, the escrow is there, and you have decided that you have just one possible way that the payment can happen, and now you're creating a second way and adding it to it. And the next one is very easy to just basically in plain English guess and then write out what it is and how you can extend this contract. And that is something that is so surprisingly easy, so to say, that programmers are sometimes hesitating because they're used to something that's much more complex. But in this case, you can really guess your way into the language, and then you get the verification whether that actually works, what you're trying to write, from the program that's called compiler that is translating this to an actual blockchain contract. Lexon also has a democratizing effect in the sense that it is working against the current trend to have big blockchain companies that are re-centralizing the decentralized landscape by proposing a huge smart contract system that is doing one task for many, many customers. Lexon instead is the premise that you have individual smart contracts that are very nicely tailored to exactly what you want to do, and that are peer-to-peer, that are just between you and somebody else who you wanted to enter into a contract with. So in that sense, it is working against the typical element that you have all the time when you have a decentralized technology, that you have re-centralizing monopolies that are bringing comfortable solutions, but at the same time taking away the actual character of this new medium. So now I would like to pause before I talk briefly about wills and ask if there are any questions.
Mr. Kaufman, are you stretching or you got a question there?
I have a question, Mr. Chairman.
Please.
Mr. Diedrich, thank you so much. That is really, it's impressive and super exciting, quite frankly. My question is this: so you referenced an Oracle a few minutes ago. In the context of that, are you talking sort of synonymously with, I'm trying to think of an example, like Chainlink or something that you could use a third party, you know, a tokenized Oracle provider to plug it into, or would this be its own Oracle service?
So yeah, thank you, Mr. Kaufman. What I'm referring to is that's blockchain language, if you want. In a sense, Oracle has become a term that is anything that is information that comes from the outside into the blockchain. So in this particular sense, this example just as a choice used the word Oracle for this, which is a pretty technical word. It could just as well have been called agent. It doesn't matter. It just basically means there is a party and that party has a certain right. And we will not in this session go too deep into how an actual contract works in Lexon, but suffice it to say that I could have chosen any noun to give a label to this party. But yes, it could also be a service by Chainlink that could be provided, that could be used, or it could be a weather service by IBM or a ticker service by Thomson Reuters, anything that brings information into the blockchain and then facilitates that something happens. So did that answer your question?
Yes, it did. Thank you very much.
Senator, yes, Senator Rothfuss.
Thank you, Mr. Chairman. Just being thoughtful and sensitive of the time of the committee, we have one more topic after this. So, Henning, let's go a little bit high level on the concepts of the use cases as we start finishing up, so that we can get to that autonomous vehicle discussion, if that's okay. And this is fascinating. I love this technology, and I think it really enables a lot of the things we're doing. So we appreciate that. Thank you.
Yeah, and this isn't our only and last meeting, so we'll, as we continue the topic forward, we can dive deeper and deeper into it as well. So don't worry too much about that. But yeah, if you would please proceed on that. And
Mr. Chairman,
Marcus, I see your hand up, but out of the interest of time, I'm going to pause you. Let Henning finish his presentation, and I'll circle back with you. And Lee's got some comments too, I know. So I'll definitely get back to you guys.
Right. Thank you, Mr. Chairman. So we will look briefly now at wills. And the example that you see on the left-hand side, I used it at UCLA, and it was actually a very funny situation, because a law professor jumped up and said, "This is not a will, this doesn't work as a will," and had a lot of things to say about it. While actually, of course, he was proving my point, because within seconds of seeing this, he was able to enter a discussion about what it does and what it shouldn't do, and so on. And that's exactly the point of Lexon. Whether the example is a good one or it could be improved is not even the point. But if you look at this, it's a very, very simple structure, so to say, for just being able to use blockchain, use crypto assets, and assign them to heirs, and then assign shares that at a certain point, if somebody gives a signal to the smart contract, will be paid out to the heirs. My major point here, obviously, is just this could be a solution for readable as text at the time of signing, and I'll leave it at this and move forward.
Hey, Henning, and Mr. Chairman, I'm sorry to interrupt. I was just going to suggest, for the sake of time, that was my only comment. Henning, your slide, like 43, that gets into the data use, I think is still a very top line description of how it can be used with any type of data. You might want to jump to those aspects if you were limited on time, as a suggestion.
Okay, I'll heed the advice to speed up. But I would like to show this. This is work that Carla Reyes has done, that has joined us for public comment in the last session. And this is the UCC financing statement. Basically, it's the form that a bank has to fill if they take on a collateral. And I don't have to explain much more. I learned that this whole system is very broken. Carla has created this with a little bit of help from me, but really pretty much on her own, which was a very exciting proof of concept for me that Lexon can work. To be a piece of law that she has actually also shown to the commission that is for the reform of the UCC. This could be a piece of law that could be on the books, that could be part of the UCC code, that could then be used by the state agencies that are responsible for actually managing these filings to run on the blockchain and be the back end of these filings. And Lexon can actually create the form out of the information in this code and create the form from it that people have to file. And this would obviously take out a lot of possibilities to make errors, and it would be really mind-boggling, and this is actually what Carla has invented. And as I said previously, I didn't even think of this, that because I don't understand enough of how legal procedural law works, that there are pieces of law that are so procedural that you can also lexonify them, so to say. And this is definitely one aspect that I would love to talk more about. If there is something that you would like to work on together to actually do this. This will probably not end up in the UCC this time around, this reform around, because it's just too far out there. But this is the reality now. This can work now. We can put stuff on the books that can be executed as a program. Now, Lexon for filing, next topic. Another thing that's also very close to the heart of Carla, but that I have worked with 2 other lawyers on a hackathon for the Eternity blockchain, which is a blockchain that is a very well engineered blockchain for financial aspects. This is a charter or a bylaws for a company, and it's just the beginning of it. And again, please read a little bit on the side while I'm talking, how this feels and how this looks. This is the definition part of the bylaws of a company, where the aim is that you can run this on the blockchain. People can basically, at the same time, file this as text, as the bylaws of the company, and then also run it on the blockchain to actually govern the business of the company. This was a very, very, it was a really strong experience, because we found some things there that also happen when you start writing stuff this way. And I won't go into this here, but it's just, there's even more exciting stuff there. The idea, of course, is that this could be something that can be used for DAOs, and if DAOs are implemented as LLCs or sub-laws to LLCs or not. And of course, it would be a great possibility to have this tap right into an electronic registered agent, possibly also running on the blockchain, to automate the entire creation of a DAO. And my experience with the ecosystem is that a lot of people have the idea that a DAO can own stuff, even if it is, because it just can de facto do so on the blockchain. And of course, usually there are laws that govern what the case really is, and many people are not aware or don't care about what the liability situation is in these scenarios. Now, not all of these initiatives are nefarious. They just, out of what reasons ever, don't care about the legal ramifications their actions might have. And there is a possibility that by enabling easy implementation of DAOs in a way that is just automatic, communities that exist will not hesitate to actually do this, and by this get the protection that they personally can enjoy from this, and also have a situation where the DAO actually really owns stuff because it is a legal entity. This is a little longer, but I will also not go into detail here. I'd be very happy to do this in another session. And again, this is something that we will also continue working on with lawyers, and for us, implementing all the details that have to be implemented for making this run. But the concept is very, very clear, and it is something that is an answer to something that is really people are looking for in the crypto communities, and that might be a new step in the evolution of how firms work. So now we're getting into Lexon for privacy. And again, I would like to say thanks to Stan to get us together here, to Lee to get us together here. And the question why we are here really was, how is Spiral Health making the data safe? How is the backend going to be worked out that patients can trust the data with? And as we just heard also from Ms. Kaiser, that we have a situation now where data is called a new oil. We have trillion-dollar companies that are mining this new resource. And until now, it is what is what can be called the Wild West, in a sense that is maybe not just a good, not just only having a good sound. And what we are looking for, of course, is a way that this resource that is being used now by big monopolies in reality can be controlled again by those who should actually be the natural owners of it. So because this is such a central element in IT and in electronic information systems, it is very likely, in my view, that smart contracts will in the future even be less about value transfer, which is now what smart contracts are all about, but more about regulating who can access whose data, what way and how, and also what is the compensation for that on a micropayment level. And this is why Lexon has a very central place, I think, in the future in being the language in which everyone can articulate in very plain English what should happen with their data. So this taps into what the big question is. So what is it even that you can talk about? What is it that makes sense for this panel, for this committee to discuss? And what I'm showing in the next few slides is what is technically possible. And I think a very important part of the answer is that any law that you are looking at should at least not frustrate what becomes technically possible at this point to protect people, and ideally protect and support it, because we can expect that there will be strong lobbying efforts from companies that have a lot to lose when these technologies are being rolled out. So the starting point is that a lot of people have reasonable qualms about trusting anybody with their health data. And this is something that is a real concern because companies as well as governments might feel obliged to use leaked data to protect themselves against the frailty that they might point to. What we're proposing as a architecture is Lexon PHI Safe, which is like a lockbox where data can only go in and it never gets back out again. The keys to the individual data points would
Henning is frozen in time.
Okay. It looks like he's frozen.
Oh,
Mr.
no, I think I just saw him come back. Henning?
Yeah.
You're back. You were frozen.
You're frozen for a
How
second.
long?
And this is, Henning, you were just frozen for a second. I don't think we missed much, but I think he's going to wrap up. But Henning, this is probably the most important area. I think if we have the time, Mr. Chairman, to just take these last few slides, it spells out kind of the data privacy issue that we've all been talking about. So Henning, you just broke up for a minute though, but I don't think we missed much.
Yeah, let's do this. You're on the last few slides here, and I'm not sure how much time you think that will take, but let's, if we could maybe, I don't know, aim for a 10-minute mark at best to knock that out of the park, and then we'll, of course we can always dive really again heading deeper into this stuff into some other meetings as well. So, but yeah, try to bring us home.
Thank you, Mr. Chairman. Yeah, 10 minutes is great. So I don't know where, I think this is a good point to pick up. People have good reasons to not trust companies with their data. What we're proposing is the lockbox where basically data can only go in, but never can get back out. The way this works is that individuals, patients, citizens keep the keys to their own data. Only they have the keys. And this brings us to a situation where we must help people to keep their keys safe, because if they lose them, the data is lost too. It can be replenished then with a new key. And do this instead of trying to protect this data trove, which in the past has often failed. The actual way that this is stored is actually on a blockchain in a decentralized distributed way. And in the use case that we would be talking about here, concretely, who we are working with is actually IBM, is the blockchain that I helped father the Hyperledger Fabric blockchain. And what they are creating now. And I've heard the criticism about IBM, and yes, there is a lot to be said there. But of course, IBM is a big company, and it's important to know who to work with. The way this works, that the data only goes in and never goes out and is still useful in some way, is that the code comes in to the data. It's a very common architecture. It's also, I worked at a project at IBM that was also doing this on a blockchain basis called analysis on the edge, because sometimes you have a completely different situation where it's just the case you cannot ferry all the data around. You have to bring the code there to process it, because otherwise the bandwidth you would have to spend is just too big. A similar way is how we're using this here. The code travels to the data, and then only the results travel back out. Lexon comes in as the rule set, as the way that you describe the rules and the program, that is, that anyone specifically can set that govern how their data is being used or not used. And of course, they can also set a price. This is a very simplistic example, but we should anticipate that only very simple starting point can invite people to actually take part in this, and then discover what more is possible. The great protection this affords is that the way that it is readable also allows for the entire legal system to act as a second shield, that if a big corporate perpetrator or a government transgresses on the will that has been articulated, the legal system can be used to get justice. The way that this works in a practical sense, sharing data, for example, with doctors, is also always going through the key. To share your data with a doctor, you can disclose whatever parts of the data you want, and it has to go through your key. The doctor, very interestingly, will, when they amend the data that is in there in your personal data trove, also sign it with their key, which gives a great incentive, additional incentive for good practice care. And then when the data should be shared with another doctor, that's also possible, and again, goes through the patient's key. The great advantage of the way that this is implemented in this case is that it can also be used for for research and for progressing science, in the way that the data in this lockbox can be statistically used, again, by the code going in and only the results going back out. So also in this case, we have a situation where you can have statistics algorithms going in, and then the data is being used, and it can also be charged for, and in a micropayment way, be a compensation being paid to the individual patient that allows the data to be used, to incentivize to not just lock it up and let nobody use it, but also to have a reward for supporting progress. This is an effort that is actually in this moment being worked on by IBM, by Intel, also by academia, and it is open source. The papers are out there. There's no lockup, and to me, this is what data management in the future will look like. So, in a word, PHI Safe will empower the patients. And with this, I'll give the microphone back to the chairman, and thank you very much for your attention.
Well, Henning, thank you. It's tremendous, and a tremendous presentation. While we were talking, I bought a couple of your books so I could study a little deeper into this, because I'm really starting to get intrigued on some of these levels. And again, we're gonna dive deeper, I think, as we move along. So just really appreciate your intellectual thought, and particularly because what you've just done is taken some of these subjects that we've been talking about over the last 2 days and brought home some real world examples for us, I think, on why it matters. And so I really just appreciate that. Marcus and Lee, I'm sure you both maybe have some comments. What I will ask is, if you do have comments, that obviously be concise, but and try not to rehash anything that we we actually have an entire topic still left on our agenda. Not to cut you guys short, but I do have to move to that item at some point. So Lee, I will note that I know you wanted to touch on particularly medical devices, talking to each other. I'm sure there may be some other things you want to elaborate on how smart contracts apply in the medical sphere. Appreciate your input. Lee.
Thank you. Can you hear me better now, Mr. Chair? Hello? Okay.
We can hear you. Yep.
Thank you. Thank you. Well, just I'd like to thank Marcus in particular, and just to thank Henning. It's an honor and privilege to be part of Wyoming and to be able to bring these kind of resources in this area. Can I share a screen for 1 second?
You may.
Okay, so I'm bringing a slide that was presented at a Board of Trustees meeting at the University of California, San Diego Medical Board that I'm on. It's the Science and Technology Subcommittee. And basically, this is just to make a point as to the severity of some of the things that you're talking about. We had to set up and this will be one minute. We had to set up a data room that looks like this in order to deal with the COVID world, with all the COVID cases that were coming in to the hospital. We're moving to more and more devices so that the nurses even have to go into the rooms. So it's not just this Fitbit world, but this world of medical is now having wearables talk to our smartphones, but they also talk to the manufacturers. We have this new word called not wearable, but insightable, where the devices that are implanted inside the body are also talking to their manufacturers, and soon they're all going to be talking to each other. So what we're talking about here, how do we reduce all of this into a plain language way that makes everybody comfortable? So I was just going to share another vision of the future that's not prominently displayed, and I thank you all for your time. Thank you, Mr. Chairman, and thank you, Senator Driscoll, for inviting us to present to the committee today. Thank you.
Thank you, Lee. Marcus, any final thoughts?
Yeah, and I'm going to cut this very short. Again, thank you, everybody. The only thing I would emphasize is you guys are in a unique position because it does sound like, Lexon I don't think is a solution. I think it's an enabler to the solutions you're talking about, right? It's not a solution itself. It's just a layer that enables the practicality of the solutions you've been discussing. I think the advantage you have is if you haven't built a lot yet, you can't retrofit this. You don't go back and write it in Lexon code or English, in plain language from Solidity 5 years from now or some blockchain code. Part of the objective here was to get you aware of this in case when you go down that journey, you can actually progress from the right starting point and start with kind of this next generation of thinking and coding around blockchain versus the costly effort of trying to retrofit at a later date, which makes it sometimes impractical. But thank you, Mr. Chairman, and everybody for the invitation. It was a real pleasure. We look forward to collaborating with you in any way that's helpful to you.
Awesome. Well, thank you, Marcus. Senator Rothfuss.
Thank you, Mr. Chairman. And I want to thank the Marcus, Lee, and Henning for joining us. This is an incredible advancement in technology potential application and way that we can realize a lot of the work that we've been doing. I think there's a lot of potential for us to partner with them and keeping in mind that this is a concept that's available now will hopefully help us to think through some of the policies that we're putting forward, just realizing that this is an approach that's available and that it's very accessible for our legal community and the public. I appreciate the engagement and look forward to additional work with all three of you. Thank you for being here, and thank you for staying on for so long when we've been running late with our other presentations. Appreciate it.
And Mr. Co-Chairman, have we been shared this presentation?
Mr. Chairman, I don't think we've gotten this presentation yet. If you would send us the presentation, a copy of it, if there's nothing proprietary, but it just went to the world, so I assume you wouldn't have put anything proprietary. So yeah, if we can get a copy of this, that would be appreciated. And if you don't mind us posting it on the website after the fact, also as a resource, I think we'd appreciate that as well, and we can make sure that gets out there. Mr. Chairman, one other thing I will say that I don't know if the three of you are aware of. We do have the Wyoming Hackathon going on right now, the Blockchain Stampede. It's largely virtual this year. So if you haven't gotten into that yet, created an avatar, walked around, and started to have some communication engagement with the folks that we have at the hackathon, that's what you can do after this meeting.
Mr. Chairman,
Clarissa, yes.
for the presentation, it is posted to the website, and Henning emailed me the presentation as well, so I'd be happy to send that out to the committee here.
Awesome. Yeah, please, if you would share that to everyone, then we can, those who wish to dive deeper can. Representative Lindholm, yes.
Thank you, Mr. Chairman. I appreciate it. I just wanted to give a quick shout out to Lee Stein. That guy's ridden for the brand. He's just a good hand, and he's done a lot for Wyoming over the last couple of years. I know he's busy on a phone call right now, but maybe I'll look back at this and he is a personal hero of mine. And then on top of that, you guys pulled in Henning. Henning's like a legend in this space. So I was just geeking out the whole time. I really appreciate it. I think that this Lexon's probably easy enough that I should be able to consider myself a software developer at this point. And
you just learned a language.
I did. Well, I think I need Representative Yen to recognize that I am.
Yeah, I think I might object to that, Mr. Chairman.
You're going to be stealing Representative Yen's clients. Good work.
I totally could now. I think I'm competing at the same level as Representative Yen. Anyways, I super appreciate this. I often think back to a couple years ago when we first started down this road, and some of the cats that were coming in to tell us what's what. Some of them weren't wearing shoes, and some of them had brought animals with them. To where we are now, I mean, it's a different world, and so I'm pretty pumped about it. Good job on picking these guys up. Thanks to Senator Chris.
Shoes, Tyler.
What's that?
Some of us still aren't wearing shoes, and we're the ones that brought them to the party. So
we don't take you out in public often, Senator Driscoll.
All right. Excellent. Well, thanks again, guys. Tremendous. Look forward to continuing our relationship as we build some great things for Wyoming and for the world. So appreciate it. We do have one last potential public comment, maybe two. Brendan Mayer, you're on.
Hi, all. Do I need to repeat my background?
For the public record, you
sure.
just
Okay,
need to
great.
identify yourself in a short little background, please.
Yes, Brendan Marr, an MIT Media Laboratory alumnus from 1998, part of the MIT computational law ecosystem, and an owner of a few companies in Wyoming. I'd like to say a few things. First off, it's a joy here to see Henning, Henning, because it turns out that we were on a conversation about 9 months ago, Daza, him and I, and a few other people, and it was clearly one of the most profound bridging of technologies. And I really want to just say, I have a deep understanding of it, and I can offer to answer any questions how this is even possible at this time in terms of bridging very low level technology, which is a small, finite state space, finite language, into something which is much larger. And the other thing that is actually very important to think about in terms of how is this relevant in terms of key stores and what's happening in the broader industry, and particularly the medical industry, what's really going on and how does all this play out? I want to give you a flavor for that. So when we look at medical data, such as images, MRI images, et cetera, what is going on in that space is those algorithms, those AI algorithms, are now becoming federated algorithms, which means that the code is actually being brought down to the machines where it exists. For example, in some cases of data, it might be on your phone. So the code comes to your phone, it's federated to the phone, and the AI operates on it, and the data never leaves your phone or never leaves the machine. So this idea of what he is talking about is really salient, and it exemplifies what is going on in the broader AI industry and in the medical community. So what he is actually saying is that we have a mechanism to take what's going on with these AI algorithms and then apply a legal infrastructure that is understandable by all on top of it. And this is really powerful stuff. And I'd be up for answering other questions. I just want to say, Representative Lindholm, one of the great joys that happened to me was when DASA knighted me a legal hacker. So I think it's pretty clear at this point we could probably nominate you a geek.
Thanks for that. No, I'm a little geeky, I guess.
All right, appreciate it. Any questions for any of our commentors? Either you or the clock has silenced the committee. But again, thank you all for your comments. With that, I think it actually concludes this topic. I will, Senator Rothfuss, I will ask you though, I don't know, Ms. Kaiser's been kind of hanging out in the waiting room. Do you know if she wants to testify on this? Because we've tried to reach her and we haven't had any luck.
Yeah, Mr. Chairman, I don't know that she does. We can invite her in.
Let's invite her. Let's invite her in and see why she's been hanging out.
And if she wants 2 minutes but not 3, we can invite her.
Sure. Ms. Kaiser, can you hear us? Radio silence. Okay. We'll proceed. If we need to circle back, we will. Lee, did you have a final comment, or are you solid?
I was just saying thank you, and I apologize for stepping off to a call that was scheduled with multi-party. I tried to be 2 places at once. Almost was successful.
We'll proceed.
The agenda kind of ruined my timing a bit today.
Mr. Chairman, Brittany's joined us. Brittany, we didn't know if you were wanting to testify on this topic or not. We saw you in the lobby. We just wanted to invite you and see if you had any comments.
Schedule with multi-party.
Sorry, it was actually Nick Spanos who was going to give public comment, but because the time has been extended quite a lot.
Mr. Chairman, Brittany's joined us. Brittany, we didn't know if you were wanting to testify on this topic or not. Brittany, will you mute your YouTube? We're still hearing that feedback from 10 seconds ago.
Absolutely.
Thank you.
Apologies.
As much as Senator Rothfuss likes to hear himself, we would like to use that.
Great,
and
perfect.
I do.
It's actually my laptop that is set up at our house, but it's Mr. Nick Spanos who would like to make a comment on smart contracting.
Okay.
Before you conclude, thank you so much.
Hey, how's it going?
Welcome, Nick.
Mr. Chairman, I got to say something really quick. Could I say something?
Please.
Thank you, Mr. Chairman. Before you testify, Mr. Spanos, we're all a big fan. We've all been watching what you've been doing in New York. Any regrets on being in New York and not Wyoming right now? And when are you moving?
Well, he's physically in Wyoming right now.
We want him to move.
What if I don't leave? I think you guys are living freer. New York had its chance apparently, and made the bit license. You know, we opened the Bitcoin Center with a live exchange. 2013, I had 100 feet from the New York Stock Exchange on retail level, and they ruffled some feathers, but we all, traded Bitcoin over there, peer to peer, and I never charged anyone, or we never took a fee or anything. People just showed up and traded. so they couldn't arrest me. But then they made the bit license. You know, we've been grandfathered in for 5 years or so right now. And they still haven't issued it. And I don't know what the heck's happened to those people. We probably gonna get in a lot of trouble. But you know, it's very difficult for someone. And you know, New York was the hub of all the activity, all the crypto activity in 2013, 2012, 2014, 2015, you know, for a long time. And chased all the companies out of there, and chased all the young people out. And you know, hopefully they come here. A lot of them went overseas, and they chased the jobs away, and they chased the new companies out. And I think you have a big responsibility, you know, as regulators or legislators. I don't want to call you regulators because you don't want to regulate, you want to grow stuff. So I want to call you growers. And you know, what's happened in other places, New York, North Korea, place like that, they stifle innovation. And you know, trapped in the minds of the youth is our future. And it's difficult enough. I mean, I think in Wyoming now, used to export, you know, jobs, people that get their degree and they'd run off or something. Maybe now they'll stay. You know, I think you're doing an incredible job. I think I should move up here. I think I'm gonna. I think you guys are great. I walk down the street, I feel free. I mean, I've been, I'm the guy that took all the arrows, and you know, it hurt. Ask me more.
Yeah, Representative Lindholm.
Yeah, thank you, Mr. Chairman. It is appreciated, Mr. Spanos. For those of us that have watched in the space, I've been watching you for a while, and it is appreciated, all the work that you've done and taking those arrows. Because of some of the missteps of New York, Wyoming was able to step forward. So it's unfortunate that your hometown did that. But just the same, we super appreciate you. We definitely look forward to your testimony. And you're always welcome to Wyoming. For those that don't know, this is a Ron Pauler. So normally I'm sitting in my office with my Ron Paul sign behind me, but I'm stuck in a hotel right now. So.
Wow. Yeah, I worked for Ron for many years. I did his data and his phone banks and advanced work and all kinds of stuff, events, and been in politics most of my life. You know, the back room when no one would see me and stuff. But it's, you know, Ron Paul brought us into crypto, brought a lot of us into crypto because he kept talking about competing currencies. And, you know, we were ready after you hear Ron Paul's message, you're ready to receive the message of competing currencies and cryptocurrencies and scarcity in finance, you know, in the monetary system. I think Ron Paul decided to run for Congress because we came off the gold standard with Nixon. And this is, I believe it's a continuation of the revolution. And I think we all have to do our part, because if we don't, you know, free ourselves with a permissionless, open blockchain, you know, they're going to imprison us and enslave us with a permission closed, centralized blockchain. You know, I mean, this is a decentralized revolution. You guys are helping out, and you know, the settlers. We were the settlers in New York. That's why we got shot with the arrows. And out here, you had Easy Street, but no, it wasn't easy for sure. So I really appreciate it. It's incredible. It's like a miracle what happened over here. And I don't know how you did it.
Ms. Long.
Thank you, Mr. Chairman. I just wanted to say hi to Nick. I am literally on my way over to spend time with you guys tonight. Thank you for spending time in WYO Hackathon and supporting our efforts. Really appreciate it. And indeed, I was around. I was actually in the Bitcoin Center right next to the New York Stock Exchange before New York screwed it up. You were ahead of your time. But thanks for spending time with us. It's all coming to fruition. Because New York screwed it up, we have the opportunity we have in Wyoming. Thank you.
Well, and to be fair, New York.
You're my hero.
New York screws a lot of things up, but that's, that's why we're here. So, Nick, do you have some general comments you want to add on the topic of smart contracts?
Yeah, sure. I think smart contracts, the only type of contract anyone should use. The paper contracts mean that you're about to hire some $1,000 an hour lawyers, and you're going to go in front of judges who are relatives of another lawyer who's representing the other guy, and you're going to lose. So smart contract deals with the mathematics of the universe, So I think and I believe that permissionless blockchains, open permissionless blockchains with smart contract technology they can execute are of the most exciting that is happening today. Have the DeFi revolution probably. There's a lot of action, decentralized finance, and that wouldn't have been possible, without smart contracts. There are things that are missing, and we're trying to get a hold of them. For instance, I think you guys spoke earlier about wills, and I remember back then, back 2013, we were building smart contracts. Also, what are smart contracts? What we were building smart contracts, not on Ethereum. So we were trying to get smart contracts to work. So the code that we had queried the Social Security master death file. And we figured we'd make a will and see if we'd be able to send the money after someone passes away. And we tried to oracleize the Social Security master death file. And so I put my mom's social in the code, and it kept paying out. And I called her up. I said, "Mom, I think the Social Security Department has you as deceased," and they did. They had a mistake. So the big problem or the challenge is, oracleization of these smart contracts, meaning getting data from the three-dimensional world to trigger financial transactions on the blockchain, on the open permissionless blockchain, so we can keep ourselves free. And I think that's one of the big things that's happening. There are a few projects. I have one of them, zap.org. There's a bunch of them. Sorry about that. And my guys would have yelled at me. So, smart contracts are changing the world today. They're not bound geographically. People are using them right now, and as every day goes by, there are more and more decentralized finance contracts that are out there. They give back high percentages. If you follow it very closely and figure out how to do it, and I think it's incredible. So, all business should be done on the smart contracts, because it's the rules of the universe that that dictate if the transaction is going to go through or not some appointed judge or whatever. Let's say you don't have the money to defend yourself, and the other side puts you through grueling depositions, and you have to tell them, all the parties you got drunk at or whatever, and all that stuff, and then you don't want to go through it. So I believe that there is absolutely no way that everything isn't going to be smart contracts. Everything will be smart contracts, and faster than you think. There are people getting rich every day with smart contracts right now. That's what I think of smart contracts.
Thanks, Nick. Interesting to note is that there are actually more lawyers on this committee than technologists or coders. It's an interesting makeup of our committee. They're diligently working to the end of their profession, although some may not know it and others may, but it's an interesting note. Representative Greer, the bewitching hour, I think hit him, and he headed to another commitment. So he
Yeah,
didn't
Mr.
get
Chairman, he had another
comments.
commitment. Exactly.
Yeah. So he didn't get to hear those comments, but I'm sure he'll follow up. So we appreciate that. Representative Lindholm?
Yeah, thank you, Mr. Chairman. Because you made the lawyer comment, I wanted to mention that there are two cattle ranchers on here and blue collar guys, and we appreciate the help in smart contracts to keep us out of our attorney's office, even though my attorney actually serves on this committee too. He is expensive.
Well, you're gonna need an attorney because you're not gonna understand what you want in your smart contract probably. So, I'm just talking about 100 years in the future.
Appreciate it.
I don't want to piss anybody off. But yeah, you're gonna need people are not tech savvy. I understand there's a product earlier is a plain English type contract, smart contract platform, something like that. And those things are gonna get more out there, but are gonna get into the marketplace more probably. I mean, I don't know if more or not, but if it's not open and permissionless, I don't want to talk about it.
Committee comments, questions for Mr. Spanos? Senator Nethercott, awfully silent.
No, I'm just entertaining the miracle that people and business transactions using contracts, smart or not, will not have disagreements or disputes. I feel confident about my ability to make a wage.
Well, depends what smart contract you're interacting with. I mean, there are smart contracts out there now that you don't even know who's on the other side. So, you bond your crypto to the contract, and whatever's supposed to happen, if it goes one way, the one person would get it. If it goes the other way, the other person would get it, or it's an option to purchase something. These are contracts that used to happen on paper, and now they're happening programmatically. And people trust open, permissionless smart contracts, audited, open, permissionless smart contracts, more so than people that actually use them, more so than paper. It's just they're not as robust because they're not really interacting with the three-dimensional world yet. But as data from the three-dimensional world gets tokenized and gets integrated into these blockchains, then you can have a percentage lease where, let's say you had a supermarket, or let's say you have a beef co-op, and you can put up on consignment your product, and people can bid on it, and if it sells, it sells. If it doesn't, it's all programmatic. And if the cow moves out of the room, it goes out one way. The person did it, his money that's already in escrow. These smart contracts are escrow accounts, pretty much, and then they'll just transfer over to the person who owned the cattle. So things are going to get automated, and maybe, I believe, better, of course. Lawyers will always be needed, and that's my reality in my brain.
Thank you, Mr. Spanos, for the comfort that many of our existences will still be relevant.
Oh, for sure.
Do appreciate all your comments. Appreciate your insight. Appreciate all you've done for this industry, for this revolution, as you called it. And look forward to. Hope you're enjoying the hackathon, and hope you're connecting well over there as well with our participants. So we appreciate that and your participation there as well.
Thank you. I love Wyoming. And remember, trapped in the minds of the young people of Wyoming is the future of Wyoming if they stay here. So keep up the good work. And maybe you'll import a bunch of other people, but make sure that they keep their ideas back where they came from. I'm just joking.
Thank you. Thank you. Okay, committee. With that, I think we are ready to move to our last and final topic. We have the Department of Transportation patiently waiting in the waiting room. We're going to go ahead and do some circulating in and circulating out of folks while we get set up here. Here comes Jesse and the general. All right. Welcome. Oh, Senator Nethercott, did you have a comment you wanted to make before we start?
Thank you, Mr. Chairman. Just a procedural question I was asked. Transportation has this bill too? Is it maybe just an explanation as to that and process what you want us to do tonight?
Absolutely, Senator. We'll definitely touch on that because Senator Rothfuss and I presented to the Transportation Committee this week. Obviously the General and Jesse were there. And part of what we're going to do, so the committee is familiar with what's happening here, we will definitely give you an update on what transportation is doing, how that relationship is moving forward, what the Department of Transportation is doing, what they will be reporting on to the two committees. And I think that YDOT has a pretty good summary and understanding of that. So I'll move to them, let them explain that, and then Senator Rothfuss and I will clean up on procedurally how that's going to function. And hopefully will all make sense with their presentation, and I think it will. General, welcome, and I do apologize for the lateness of the meeting, but thank you for sticking around and joining us so late.
Yeah, you bet, Mr. Chairman, members of the committee. Always a pleasure, and I look forward to talking about this autonomous vehicle. But I tell you, maybe maybe I'll make a couple comments and then kick it over to Jesse Kirkmeyer, who's really our lead on this. But I would just say that, in terms of, Senator Nethercott, you're correct. We presented this to the Joint Transportation Committee on Monday or Tuesday this week. And if you look at, from my perspective of this bill, the purpose and mission of YDOT: support the economy, connect communities, make life better, and provide safe and efficient transportation systems. And I think we're in the business of ensuring our capability to do that with the advent of autonomous vehicles. And so what the bill covers really in summary is, key policy and procedures that we need in the state to accomplish that, key operational considerations, key infrastructure requirements, and the legal framework. Additionally, there is a section in there to support the testing of vehicles on our road, which is one of the great interests of this committee. And so there's some overlapping interests here, which really the bill actually does a pretty good job of capturing. The short story is, after the guidance we receive from the committee today, Jesse Kirkmeyer is the head of our work group. Will really take those comments and submit the comments to both committees for the road ahead. And I'll tell you, I do have to thank Jesse and an entire work group for the work that they have done, because it has been a big lift, and I think they've done a nice job of pulling this stuff together. So with that, Mr. Chairman, with your permission, I'll kick it over to Jesse maybe for a bit more, and then you can take it from there as far as the road ahead.
Yeah, I appreciate that. And Mr. Kirkmeyer's maybe a little bit to further Senator Nethercott's question. So the end result is a timing deal, is what it is. And the bill exists in this committee, and it exists in the Transportation Committee. What the Transportation Committee did was it heard testimony from the working group, and Mr. Kirkmeyer is going to summarize that for us. And so they heard testimony from the working group. The committee made the transportation committee made the decision to table the bill until its final meeting, because the working group and industry testified as well as the trucking association. And there's just a lot of input that led us to the belief that considerable work would need to be done with the legislation before transportation would fully consider it. The timing issue is that their final meeting is long into the year, late into the year, I should say. And so in order to preserve the topic from potential loss, what we believe we came to the conclusion on is that it makes sense to run this, the legislation will run simultaneously in these two committees, although that may seem a little redundant. We're not sure, we don't want all of the working group's hard work to go to waste. We're not sure whether the transportation committee will actually sponsor the bill at the end of the day. We're not sure if our committee would sponsor the bill at the end of the day. But if both committees were to produce a bill, it will mirror virtually, at least it should. And one committee would, at that point in time, will just decide who's going to run with it if a bill moves forward. That way we don't end up with nothing if we have the opportunity to have something. So hopefully that makes sense. It creates a little bit of redundancy, but we're trying not to drop the ball on the working group's really hard efforts. And with that, I'll turn it over to Mr. Kirkmeyer, who leads the working group and can provide much more detail on where they're at and where they're headed.
Thank you, Mr. Co-Chair and members of the committee. Yeah, I think you did a very good synopsis of what is happening. We got the original draft of the bill about 2 or 3 days before the committee met. I quickly sent it out with permission to the working group and identified probably about a dozen, not necessarily friction points. Most of them are just points of clarification brought up by the members of the working group. Got a pretty broad spectrum of folks. And to be honest with you, they don't all agree with each other on what should be in the legislation. But after sending the first draft out to them, I got a lot of comments. I consolidated them into kind of one form to identify where we had issues we needed to work out. And a lot of them are just having to deal with our current definitions and how they'll come out in the law. So based upon what happened Monday and with your presentation and your meeting today, I offered really to take what we've currently done and then change it based upon guidance I get from you folks today, send it back out to the working group for review, and hopefully eliminate most of the clarification problems or friction points. And then whatever's left, identify, we'll quickly address them in our October 15th meeting. And then after that October 15th meeting, I'll give you back all the comments on the draft legislation and highlight where the members don't agree. And then just turn it over to you, and you will have kind of a product ready to go from us. You'll know where we agree on things and where we don't, and where we don't, the options that the members prefer to see. And then from there, you just take over as the legislators and make the final decision from there. So really the goal is to give both you and the JTC the same product. You meet earlier than they do, I think around the 2nd or 3rd of November. So you'll have and they meet at the end of November, you'll both have it. If you want us to do additional work between after you get it and before your November meeting, we can do that for you, and likewise for the JTC. And then hopefully at that point, you can decide how to move the legislation forward if you so desire. And I'll stand for any questions.
Is that helpful, Senator Nethercutt? Great. Senator Rothfuss.
Thank you, Mr. Chairman. And we can decide whether we want to take it up in the November meeting or whether we want to wait until our December meeting and basically give transportation sort of the first right of refusal for it, which I think is probably logical, recognizing that we'll probably have a pretty full November agenda for a one-day if that's what we end up doing. But that's something the committee can contemplate, and we don't have to decide that today.
And that's a good point, Co-Chairman, because when we met with transportation at the beginning of the week, we were having 2 November meetings, and now we're having the November-December meeting. So as things evolve, we're definitely figuring this out. And I think that's right. Okay, so any questions, Mr. Kirkmeyer? Did you have anything else to? I mean, substantively, we're receiving that in later in October in our November meeting.
Yes, Mr. Chairman, I did send you and the co-chair the initial kind of check sheet where we had some concern or some suggestions. I worked on that yesterday with the staff, and we've kind of come up with staff solutions. Pending any additional guidance you give me today or anything else you want to see, you've identified, you want added, you want changed, I'll send that out tomorrow to the work group. I'll probably get most comments back within a week. So I will adjudicate things then and send out a final that we will review in our 15 October meeting. So that's kind of where we're at. I think around the 16th or 17th, you'll have a package pretty much laid out for you with discussion points, friction points identified, and stakeholders who don't agree and where they don't agree and what their positions are to hopefully make it as seamless for you as possible.
Okay, thank you, Mr. Kirkmeyer. What I do know is that, well, one, if the committee doesn't have questions for him, I do know we have some public comment, which I think may help add to his direction. Committee, do you have questions for the working group or the general? Senator Rothfuss.
Thank you, Mr. Chairman. I'll just say that, I'm very comfortable with the draft as it is right now and with the direction that the Transportation Committee is going to go, because they're basically just trying to address challenges of this model legislation. So I think we're in great shape. And I think that our best approach as a select committee is to watch the process probably through December. And then if we have concerns, we can pick it back up. But hopefully, what we've heard will proceed as planned, and I think we'll be in great shape. So I'll stop there.
Okay, I'm tracking with you. I concur. With that, what I do want to bring in is I've got Lynn Elliott with the American Property Casualty Insurance Association and Miss Wilkinson, who want to provide some public comment, and we'll see if that maybe adds anything to our working group. Catherine, welcome.
Thank you, Mr. Chairman, members of the committee. Catherine Wilkinson, representing American Property and Casualty Insurance Association. Mr. Chairman, just due to the time and hearing some of the previous discussion and the direction the committee is going, I would just like to reserve my time for the future. I am part of the working group and will continue to be an active participant. So thank you.
And thanks, Ms. Wilkinson. And do you know, does Miss Elliott want to provide any comment, or you're the comment on behalf of her to reserve your comment?
Mr. Chairman, Miss Elliott had to leave due to another commitment, so we were just tag teaming today with other commitments. So thank you. Okay,
perfect. Well, I just want to make sure we're affording the opportunity. So then I think we're all on the same page on where we're headed with this. Committee, hope that all makes sense, and I don't have anything else. I'm comfortable with the process that we've laid out. Co-chairman, you're good.
I'm good. I think that sounds great, and we're always happy to hear Ms. Wilkinson when we start taking action. So I think that's good approach.
Yep, that sounds perfect. I know she has some substantive comments regarding the draft itself, and that'll come at some point in time. So we'll be ready for that. Okay. With that, committee, and no questions, no comments, seeing none, and seeing you're all eager to get to your evening and what is left of it. It's Representative Lindholm. Oh, welcome, Representative Lindholm, to the closing portion of the committee. Okay, with that, we're wrapping up. Let's just make sure that any directives we provided LSO, we're on the same page. David, Clarissa, David, we haven't given you a whole lot, but we have given you some. You want to run through that with us?
Thank you, Mr. Chairman. Also has been directed to draft a bill on digital identity based on the discussion and some of the language provided. I did have one quick question on that, and I'll go back and review the discussion, but I may have just missed it. Was there a decision on whether or not self-sovereignty would be included in that digital identification definition? Did we decide to unbracket that and include it?
Mr. Chairman, yes, I think that's where we're starting. Self-sovereign stays.
The committee sponsored the interstate crowdfunding exemptions bill as amended. The committee made some amendments to the Public Benefits Corporations bill and tabled that discussion for the next meeting. They directed LSO to work with Mr. Land, the Division of Banking, to provide a formal draft for the out-of-state state banking charter conversions. The committee directed Mr. Land to work with LSO and draft a bill based on the memo provided with respect to those changes they had brought forward. And then, so as far as I know, those were the directions to LSO. I think beyond that, things have just been continued to the next meeting based on these discussions. So if I missed anything, that's what I've got.
That's what I have. Co-chairman, you have anything else?
No, I think we're in good shape.
Awesome. Well, David, Clarissa, thank you for all your hard work and obviously sticking with us into the late evening. We appreciate all that you do for this committee.
Yes, thank you, Mr. Chairman. Thank you all so much. Have a great night.
Have a good night.
Excellent.
All right, folks.
Mr. Chairman, I was just going to say, I don't know if there's any final comments from the committee or if there's any general public comment, but I think we're done with that because nobody'd stick around this long, but don't know if there's anything else.
Do we have, Clarissa, do we have any general public comment that you're aware
I
of?
don't have anyone else lined up for public.
Perfect.
Yeah.
Okay. Well, good. So then committee, any final thoughts, comments? Representative Lindholm.
Thank you, Mr. Chairman. All of the elected officials are invited to the VIP event tonight. If you're in Laradice, it'll be lots of fun and not exhausting after your day at all. Well, and not just elected officials, Matt Kaufman, Joel Reville, if you guys want to make quick feet over to Laramie. There it is. That's all I got.
Appreciate that invitation, Representative. Okay, with that committee, thank you for all your hard work. Thanks for sticking with us, and we will meet again. Take care, guys.
Thank you.